going today? Happy today Wednesday? Wednesday? It is Wednesday, right? I was supposed to say happy Monday for some reason. Oh gosh. Happy Wednesday, y'all. How are we doing today? We have a Sarah Boone hearing in about 20 minutes. Now, let's take a look on the court's website because, James Owens was given a deadline of Friday, 11:59 p.m. to file his motion to suppress. And I was actually surprised to see that it was filed on Monday instead, 3 days later. So I don't know if he was able to privately contact the judge and it hasn't been notated on the court's website yet that they extended that deadline to him. But I saw that it was filed late, or it seems like it was late. And then there's some other stuff that's on the court's website. Nothing too crazy going on over there. But I hope you guys are doing well. Hi, Kay. I saw you're here earlier. Hi, Nerdy Nisi. Hello, hello. Moondog here as well. Pretty good. Work is quiet today. Is that a good thing? Is it good to have work that's quiet? Or is it better to be super busy and the time goes by faster? I mean, sometimes when it's quiet at work, though, you can be doing other things that's not work related and pretend like you're just working. Hi, Ashley. How are you doing today? Hello, hello. All right, well, let's see what's going on here. Let me review some of the stuff with you guys. I think since I last saw you guys, here are the new stuff that's on here. I already looked at them, and I don't think... Oh, actually, there was some that was posted today. I haven't looked at those yet. But let's see what's up with these. And then also, I want to watch the Sarah Boone interrogation today. So I was thinking maybe we'll watch a little bit before the court starts. Give it some time. Hi, Rebecca. Hello, Christine. Hello, hello. Oh, hi, Sarah. Thank you so much for covering the case so extensively. Your lives make my day. Hi, Kate. Oh, hi, Sarah. Thank you so much. I appreciate that. Oh, gosh. Okay, so I didn't bring my glasses here, but I could still read this. All right, so what do we have? Statement memorandum regarding defendant statements to Deputy Kayla Rodriguez and Detectives Colpso and Lowen. If you guys remember, Detective Kayla Rodriguez, I believe I remember correctly, is the one with the body cam footage, the one that was really nice and tried to be as accommodating as she could to Sarah Boone. You know, when Sarah Boone wanted her cigarettes, wanted her Dr. Pepper, she's like, no, you can't go in there. It's a crime scene. You can't be taking things in and out of there. And I think she was trying to get Sarah Boone some water, couldn't find any. She was trying to see if any other officers had cigarettes to give to Sarah Boone. But if I remember correctly, her name was Rodriguez. And then Detective Colpso and Lone were the ones that did the interrogations. Now, let's see. What do we have here? Deputy Kayla Rodriguez, in response to a 911 call made by the defendant shortly before 1 p.m. on February 24, 2020, responded to the defendant's residence. Number 2, Deputy Rodriguez activated her body-worn camera while still en route to the defendant's residence. All interactions with the defendant were recorded. 3, there are 3 recordings. A, one begins at approximately 1:08 p.m. and lasts 13 minutes and 32 seconds. The next starts approximately at 1:22 p.m. and lasts 4 minutes and 56 p.m. or 4 minutes 56 minutes. And then C, the final one starts at approximately 1:30 p.m. and lasts 5 p.m. 5 minutes 30 seconds. Is this right? I feel like these times are so short. Are these hours? Or, I don't know. I thought there were minutes, but I don't think there were hours, though. Okay, so anyways, at no time was the defendant in anything that resembles custody for Miranda purposes. Ramirez v. State. The Ramirez case outlines the famous 4-factor test. A, the manner in which the police summoned the suspect for questioning. B, the purpose, place, and the manner for the interrogation. C, the extent to which the suspect is confronted with the evidence with his or her guilt. And then D, whether the suspect is informed that he or she is free to go to leave the place of the questioning. 5, while Deputy Rodriguez would not let the defendant enter the crime scene, no cigarettes, no soda, Dr. Pepper, whatever it was that she wanted besides Dr. Pepper. I don't like Dr. Pepper. Dr. Pepper is nasty. The defendant was not in custody. 6, the deputy was the first responder trying to give preliminary information about what might have happened. The defendant was spoken to on her porch and then sidewalk area just outside of her home. She was not confronted with any evidence because at that time there was nothing to confront her with. The defendant was informed she was not free to leave the area due to the investigation, but the restraint of her freedom of the moon was never resembled a custodial arrest. Like, she was free to roam around, she was free to, drink from the hose, but she just couldn't leave that area because obviously, there was a dead body that was found in a suitcase in her apartment or in their apartment. Number 7. Hey, Nicole, how are you doing today? Hi, Katrina. Hello, Forky. Hello, hello. Thanks for popping on in, guys. Number 7, just under 4 hours later, she was interviewed by Detective Colpso and Lowen inside an unmarked car on scene. Although under both Ramirez and Rinkin, this is not for custody This is not custody for purpose of Miranda. She was given her Miranda warnings. 8. For the reasons outlined in the state's response to the defendant's motion to suppress statements at Orange County Sheriff's Office, the Miranda warnings were not defective and her waiver of Miranda rights were voluntary and her statements was voluntary. Hi, Kay. 9. Any motion to suppress on these statements should not be granted. Filed by Mr. William Robert J. Yeah, so these are minutes. Oh, are these? Oh, I see. These are just the interactions with Sarah Boone. Okay, I was just thinking the body cam just being on, but they're just talking about any interactions that she had with Sarah Boone, I guess. Okay. A meta notice of taking deposition. So they're doing the deposition of Dr. Michael Brannon. Dr. Michael Brannon was initially supposed to be a forensic psychologist expert, but then I guess he is now labeled as the clinical psychologist, because the forensic psychologist is going to be Dr. Julie Harper. State's request for a protective order. Okay, so this one is kind of a little bit snarky. Hannibal Crossing. Hi, how's it going? I don't think I've ever been so excited for a trial to start. I feel like I'm not ready. I don't know. It doesn't feel real that this trial is going to start next week. It doesn't feel real at all. I don't know. I guess when it happens, I don't know, maybe it'll feel real then. Hi, Fred. How are you doing today? How's it going? So this is the state's request for a protective order. 1. The defendant in her third amended witness list has listed 4 people as witnesses. A. Custodian of Records, Orange County Office of State Attorney. B. Domestic Violence Supervisor for the Office of State Attorney, 9th Judicial Circuit, Orange County. C. Victim Advocate Supervisor for the Office of the State Attorney. D. Misdemeanor Supervisor for the Office of the State Attorney. 2. The state requests a protective order under Florida Rule Criminal Procedure because anything these witnesses can say about the defendant and the decedent would be protected by the work product privilege. 13. If the defendant wants a public records from the state attorney's office, she should do what everyone else has to do. File public records requests. Ooh, but I don't know if that's going to come in through in time because, trial starting next week. 4. Subjecting prosecutors and their staff to this type of discovery for the investigation will require disclosure of work product and seriously impede criminal prosecutions. Egan v. Demanio. 5. We believe the trial court was right the first time in denying the pretrial defense efforts to subpoena the 2 state attorneys and inquire into oral communication, sworn or otherwise, between them and a state witness. The oral and unrecorded statements of witnesses of a state attorney are privileged as a work product and not subject to discovery. 6. Opinion work product involves a lawyer's impressions, conclusions, opinion, and theories of her client's case. Opinion work product is an absolute or nearly absolute privilege. Horning Keating v. State. 7. Fact work product concerns what the attorney did and what she learned in her role as the attorney. As the name suggests, fact work product is factual information which pertains to the client's case prepared or gathered in connection therewith. Citing Rabin. 8. The fact work product is discoverable only if the parties seeking this work product show the court 1. The need of the fact work product to prepare a party's case. A party's case. And 2, that without undue hardship, the party is unable to obtain the substantial equivalent of this fact work product by other means. Thus, need and hardship elements must be alleged in the motion to compel and establish to the court's satisfaction at an adversarial hearing. I mean, something just tells me that James Owens is just really short on time. And, he probably would try to get his information himself. But the reason why he's reaching out to the state to give information, to them is because they're just short on time. He's like, hey, you know what, state? Just make it easier for me. Just give me the information that I need. And the state's like, no. That's not how things work. I mean, like I said, we have another week before the trial starts, okay? 9. The state is at a loss for what non-privileged testimony any of the people listed above could provide in this case. Number 10. Therefore, the state is requesting the court to enter protective order to prevent any employee of the state attorney's office from being a witness in this case. So let's see what the judge says. I also want to know what the judge is going to say about the motion to suppress. Because like I said in the beginning of the stream, I was pretty clear that the motion to suppress, that's going to be filed by the defense. It has to be filed by Friday night, not end of business day, but end of day. And then we saw the motion to suppress was filed on Monday instead. So I just wonder if the judge or anyone's going to have any issues with that, or, maybe there were some things with, I don't know, maybe Mr. Owens couldn't do it because, maybe the hurricane also affected him as well. Hey Madison, how are you doing today? Hello, hello. What's up, Jelly Bean? Hi, Verna. Good afternoon, everyone. I agree. The case almost feels been ongoing for so long. It feels surreal to be happening. I'm just like, it just doesn't feel like it's happening. I don't know. I guess I haven't really accepted it yet, but you know, who knows? Maybe a week from now they've already gone through jury selection and it's going to be opening statements. We'll see. Oh, that's right. Yes, I'm curious if she gets her professional makeup done. I mean, I don't know. I don't know about like I don't know. It's like a glam squad for your makeup and your hair. I don't know about that. I think she looks pretty okay, decent the way she looks right now. Like she looks fine. Her face looks fine. I think her hair looks fine. Give her some decent clothes, and I think she'll be okay. I don't think she looks all jacked up or anything like that. You know, I think she looks fine. But I don't know if like the makeup and all that stuff is really going to help her that much. Because I feel like her hair's so short. I don't really know what you could do with her hair. Maybe get like a little clip, maybe clip some things on the side or something like that if you want to, maybe. In terms of makeup, I don't know. Maybe a little bit of mascara. I don't know actually. I don't really know if she really needs that makeup. I think her natural face looks fine. Amended motion to suppress defendant's statements at Orange County Sheriff's Office, because sometimes when you do the makeup thing and either someone doesn't know how to put makeup on you or you try to put makeup on yourself, you might be looking like Lori Vallow the clown, okay? Because Lori Vallow, I don't know where she got her prison makeup, but she'd be showing up to some hearings, man, with some like bright red cheeks, you know, with some eyeshadow, with the lippy and stuff, and she just looks horrible. I don't know. I know she's trying her best to look good, but it just sometimes doesn't look very, very nice. Okay. Or I guess like if Sarah Boone gets really sweaty, maybe like some like powder foundation. That could help a lot if you get really sweaty, but I don't know if she does or not. Shiro's a lawyer. Corky is just a legal aid. Shiro is he is sleeping right now. Okay, this guy he's always on vacation. All right, he's still on PTO right now. So I'm just carrying. I'm doing all the work right now. Jolly Rancher lipstick. Yeah, I mean, like if you can, I know that's like a trick that people do with like you can do with like candy or something. You know, get some like candy, and then you can make your lips red and all that stuff. But I don't know. Like I'm just saying, Lori Vallow just did not look good. I made a little mini snippet video of Lori Vallow entering into the courtroom as she was like a goddamn pageant queen, and she just looked very silly. All right, so amended motion to suppress defendant's statements at Orange County Sheriff's Office. This was filed by amended motion. Yeah, this is filed by Mr. Owens. Oh gosh, what? Oh my god, my mouse is acting up. All right. Oh, you know what? I was hoping we could watch the interrogation before, but I think I'm gonna get through all the docs and then we'll get to the hearing, and then we can watch the interrogation afterwards. Number 1, defendant Sarah Boone is charged second-degree murder. On or about 24th of February 2020, defendant called 911 in response to finding her boyfriend George Torres deceased. 3, Deputy Kayla Rodriguez at the Orange County Sheriff's Office arrived on the scene with her body cam activated. Upon arrival, Deputy Rodriguez spoke to the defendant and realized a death had occurred. Deputy Rodriguez advised her supervisors and secured the scene. 4, sometime later, homicide investigators Chelsea Connolly, aka Chelsea Copso, and Scott Lowen arrived. These 2 investigators would ultimately be responsible for this homicide investigation and were involved in the interrogation of the defendant at the Orange County Sheriff's Office the next day. 5, the defendant was ordered to remain on the scene while Orange County Sheriff's Office conducted their investigation. As ordered, the defendant stayed outside of her apartment for several hours until the investigation was completed. 6, hey, how's it going? We have Tuco, Roxit, hello, hello. I wouldn't be surprised if the 2 dogs are called as character what is the defense of this case. Was there a hearing today? Yes, the hearing should be starting in about 8 minutes, case. We are just waiting for the hearing. Number 6, at some point, the defendant was told to get into an unmarked vehicle with Detective Colpso and Detective Lowen. Once inside, Detective Colpso recorded an interrogation with the defendant after partially reading her Miranda rights, omitting the final question. The defendant was advised that this recorded interrogation was routine protocol and official procedure for any death investigation. I mean, honestly, we listened to this audio recording in the car about a couple days ago. I think there should be a standalone video posted on my YouTube channel. Did I forget? No, I don't think I forgot. I think the video is up there. Oh gosh, I hope I didn't forget. I actually forgot to post the Hannah Reid hearing that we watch. I completely forgot to post a video of that on my YouTube channel, but the live stream is up. Y'all can watch that. I'm sorry. So we listened to the audio recording, and you know what? When she read the Miranda rights, it was clear and cut to me. Okay, and I think at the end she's like, "Do you understand what I'm saying?" And she's like, "Yeah." Sarah Boone responded, "Yeah." So that's what I remembered. Number 7, during the investigation, Detective Colpso asked to see the defendant's phone. Defendant told the detective her phone was on the kitchen counter in her apartment. The detective brought the defendant her phone and instructed the defendant to unlock it. Defendant complied with the demands of the lead investigator. 8, after Detective Colpso had the defendant's phone for a period of time, she came back and told the defendant that she was taking her phone. Detective Colpso asked the defendant to sign a form releasing it to the Orange County Sheriff's Office for further investigation. The defendant acquiesced to the authority and signed the form. Remember, they were trying to... Was it what Sarah Boone was pro se? I think she was trying to say that, like, oh, you know, they seized my phone without my permission or something like that, or they did it in an unlawful way. Number 9, the defendant was told that one of the detectives returned her phone to the defendant at her apartment in Winter Park the following afternoon. 10, later on that evening, the defendant moved to her ex-husband's home. Oh, God, poor Brian Boone. For the night. Using her ex-husband's phone, the defendant called lead detective Chelsea Colpso on her cell phone to express her concern that Detective Colpso was not being truthful about law enforcement motives as it relates to the defendant. The defendant told the detective she believed they were trying to trick her and being sneaky about something. 11. The detective assured the defendant that they were not trying to trick or implicate her. Oh, I wonder if this recording. I wonder if this phone call is recorded. It has to be, right? Do you think they're going to play it in trial? But that following day, the defendant needed to drive to the Orange County Sheriff's Office to retrieve her phone. The detective explained that the reason for the change in plans was because she was pregnant, not feeling well. 12, the next day, February 25th, 2020, the defendant arrived at the Orange County Sheriff's Office to retrieve her phone and had questions about this tragic event. Yep, she showed up. She had, I think, like a little notepad with her questions she was going to ask. Upon information believed, a judge had signed a search warrant for the defendant's phone just 9 minutes before she arrived at the sheriff's apartment. 13, while still under the impression that she was retrieving her phone, Detective Lowen led the defendant upstairs into the interrogation room. Detective Lowen wore his firearm in his waist during the entire event. A custodial interrogation ensued. Immediately after the interrogation, the defendant was formally arrested and charged with the offense above. So there's a 2-hour interrogation that was recorded. We're going to watch it today. The initial dialogue between Detective Colpso and the defendant Sarah Boone. Detective, I'm going to have you sit in the green chair. Detective, appreciate you coming in. Sarah Boone, yes, ma'am, I want to ask about these whenever you have a moment, referring to her written notes with question. Detective, sure. Detective, so obviously he received his autopsy. Detective, so I'm going to read you your rights again because we have to talk about it. Detective, and we're not done talking about the incident. Detective, we just have to do it. Sarah Boone, just like what we did yesterday. Sarah Boone, normal protocol. Detective, just like what we did yesterday. Detective, remember, I read you your rights. Detective, yeah, it's the exact same thing, but since I'm asking you the follow-up question, I need to read them to you, okay? Detective, so you have the right to remain silent. Anything you say may be used against you in court. You have a right to talk to a lawyer before and during the questioning without charge. If you can't afford an attorney and want one can be provided with you, for you before questioning without charge. Has anyone threatened you or promised you anything to get you to talk to me? Sarah Boone, no. Detective, and do you understand what I just read to you? Sarah Boone, yes. Detective, perfect. Okay. Detective, so this morning we went to the autopsy and we were informed of the injuries he had by the doctor. Defendant, where? Detective, so he's got a scratch marks on his back. 16. The interrogation continued for approximately 2 hours, and at the end, while still in the interrogation room, the defendant was placed in handcuffs and was arrested. Is this the amended version? Because is this the amended version? I don't think this is the amended version, is there? Because, you know, when we look at Mr. J, the assistant state attorney's motions and responses to motions, you know, there's a bunch of case law backing it up. And I'm like, ain't there supposed to be some case law in here just so the judge can kind of, you know what angle you're coming at? 16, the interrogation continued for 2 hours. Oh, I read that already. 17, hey, beautiful, messy ball. Hello, hello. How's it going today? Sarah has more snottiness in the voice. I haven't practiced my Sarah Boone voice yet. I could do the Elaine one, you know, because the Elaine's is like kind of fun to do. The Sarah Boone one is like really like meek and like a little bit of a high pitch. Lady, hi lady, hi go lucky. How are you guys all doing today? Hello, hello. 17, detective read the defendant her Miranda rights directly from the printed card. Detective omitted the final question printed on the standardized Miranda card at the Orange County Sheriff's Office. The detective omitted the same Miranda rights question that she omitted the day before. She omitted the final rights. Question is, having these rights in mind, do you wish to talk to us now? 20. The defense has yet to receive a true and accurate copy of the Miranda rights card from the Orange County Sheriff's Office. 21. Upon information belief, it should look like something like this. 22. Based on all the circumstances surrounding the interrogation, the defendant's statements was coerced and not freely and voluntary given. The defendant did not freely and knowingly waive her rights under Miranda. As such, the entire 2-hour interrogation should be suppressed. Mr. Owens. Okay. This is just like an amended witness list. Mr. Owens. What else is there? Provision of defendant's 4th amended witness list. Mr. Owens. This one is for today's hearing. Motion to suppress. Let's see what the judge says. Motion to suppress. I feel like they need to update this because Mr. Winston Hobson, his name is still on there. Take Mr. Hobson off this case. David Verrett. I don't remember who David Verrett is. Rachel Fugate is the one who was helping with providing Sarah Boone the clothes. And then here are Sarah Boone's 3 attorneys. Mr. James Owens is coming in virtual. No! I want him to go in person. I mean, I guess it's a travel. You know, it's not worth him driving all the way down. But poor Mr. Owens. I hope he has his tech stuff in order. It was a little bit rough for him last time. Notice the provision of the state supplemental witness list by Mr. Cacciatore. All right, so maybe the other 2 attorneys will appear in person with Mr. Owens being virtual. Refresh. The doc was. Is there more stuff now? Let me refresh. Dude, this case. Sometimes they be posting things very last minute. Oh, there's another motion to suppress. Huh? Oh. Okay. Wait, do we got case law stuff? Hey, they were listening to us. All right. Well, while we wait for the. Okay, so Judge Krenick is here. Hi, Judge. Well, he's not here, but his desk is here. Beautiful looking desk. Oh, there's some jiggling around. He posted some case law from the Miranda. Let's read them really quick before they talk about it in the hearing then. Okay. Procedural posture. September 30th. Defendant filed a amended motion to suppress attachment. 4. Where a defendant is subjected to custodial interrogation, he must be administered the proper procedural safeguards commonly known as Miranda warnings. See Miranda v. Arizona. In the seminal Miranda v. Arizona decision, the Supreme Court enunciated this bright-line rule to guard against compulsion, the coercive nature, and atmosphere associated with the interrogation. 2. Assure the individual's right to choose between silence and speech remains unfettered throughout the interrogation process. I mean, most of the Miranda was read. To me, it seems pretty clear. 5. While the defendant may waive effectual of these rights, such waiver must be made voluntarily, knowingly, and intelligently. That's what it seemed like. The court must make a case-by-case determination based on the totality of the circumstances whether the waiver was constitutionally sufficient. Are they here yet? Nope, not yet. 6. Therefore, the Miranda warning and waiver demonstrated by the prosecution. No evidence obtained as a result of interrogation can be used against the defendant. All right. 1. Defendant was in custody for purpose of Miranda. 7. Custody encompasses not only the formal arrest, but any restraint on freedom of movement of the degree associated with the formal arrest. See Trailer v. State. A person is in custody if a reasonable person placed in the same position will believe that his or her freedom of action was curtailed to a degree associated with the actual arrest. 8. It is uncontroverted. Defendant was in custody for the purpose of Miranda. On February 25th, 2020, defendant arrived at Orange County Sheriff's Office where she was directed to an enclosed interrogation room. Therein, she was surrounded by 2 detectives, Kopsel and Lowen. Furthermore, Lowen's firearm was visible in the waist throughout the interrogation. Therefore, it is reasonable for the defendant to believe that she was not free to leave at that time. No one here yet. I'm going to keep checking. Okay. But I feel like for his case law, it needs to be super specific to what he's claiming, right? Saying that like, oh, well, you didn't read the Miranda cards to the T. I feel like you have to get as specific as you can. Maybe we'll get there. 2. Defendant was subject to interrogation for the purposes of Miranda. 9. Interrogation is any questions or actions by the state agent that is likely to elicit an incriminating response. 10. In this instant matter, defendant was directed to an interrogation room where she was subject to investigative questionings for 2 hours. It is undisputed that the line of questioning exhibited by both detectives was likely to elicit incriminating responses. Therefore, this court should find the defendant was subject to interrogation for the purposes of Miranda. You know how there's a picture of Sarah Boone and it's her mugshot and she's like slightly smiling? Was that when they arrested her? Was that when they took that mugshot? Because I don't know. I was looking on Google the other day. I was like looking for like Sarah Boone pictures and stuff for like thumbnail, and I was like, huh. I don't know. I guess it never really caught onto my mind that she was like kind of smiling a little bit in this. It looked like a mugshot, but I don't know if it was the mugshot when they arrested her the first time, or maybe they just took like maybe they did the Window Adelson thing where it's like, hey, you know, like can you stand up, Wendy, and like let us take an awkward picture of you really quick just so we have it on file. Oh wait, people are coming in. Hold on. Oh, good. Mr. Owens is there in person. Yay! He's there in person. No tech issue. Lori knows that he has about 5% chance of winning this suppression. All right, 5% chance. What helps in his 5% chance? Did he mention that? When did he file this? Like, I don't know. Like, this was uploaded a couple minutes ago. Should I continue reading? Well, I mean, they're walking back and forth. Okay, I'll read like a paragraph and then we'll go back and forth. The state has not proven that waiver has made knowingly, voluntarily, and intelligently based on the totality of the circumstances. 11. A court must determine based on the totality of the circumstances where a voluntary and intelligent waiver of Miranda rights has been made. In making this determination, the factors considered by a court included the background, experience, and conduct of the accused. North Carolina v. Butler. 12. First, the detective minimized and downplayed the significance of the Miranda rights before interrogating the defendant. See Ross v. State. Holding where police minimize and downplay the significance of the warnings, the very purpose of Miranda is undermined. In this instant matter, the purpose of Miranda was undermined as follow. Detective, so obviously he received his autopsy. Detective, so I'm going to read you your rights again because we have to talk about it. Detective, we're not done talking about the incident. Detective, we just have to do it. Sarah Boone, just like we did yesterday. Normal protocol. Normal protocol, right? Detective, just like we did yesterday. Remember, I read you your rights. Yeah, it's the exact same thing, but since I'm asking you follow-up question, you need to read them. I don't know. It doesn't really seem like it's downplaying it to me. Maybe sort of sounds like you're downplaying it when you're saying like, let's see, we just have to do it. Does that sound like we're downplaying it? It sounds like, hey, this is something that's important. We have to do it, and I have to do it again, just like I did yesterday. I don't know. That's how I interpret it. Number 13. The aforementioned line of communication highlights. Oh, that's right. We could see when. Here we go. 10 to 2:35 p.m. So about, 35 minutes before the 3 p.m. pretrial. Where was I? I was over here. The aforementioned line of communication highlights the coercive nature a detective. I just want to say detective. I just want to say defective. I don't know if it's because I don't have my glasses on. The aforementioned line of communication highlights the coercive nature Detective Colps's action. In addition, it is apparent that the defendant believed at the time that she had to speak with detectives and that the warnings were just a form of protocol. I don't know, man. I think Sarah Boone went in there thinking that she can wiggle her way through out of this. I really think she did. Second, defendant was not improperly informed of her rights to make a voluntary intelligent waiver of such. Detective Colpso failed to ask the defendant, having these rights in mind, do you wish to talk to us now? Oh, gosh. I just feel like, I don't know. It just doesn't feel like enough to me. Like, yes, he, provided case law about, how Miranda has to be read, how the person that it is being read to, they have to understand, they have to be they have to intelligently, I hate that word, waive it, be set of mind. I mean, okay, yeah, I see the case law for that, but then I feel like there needs to be a little more specificity. Like, oh, well, here's a case law where the detective didn't read until the very end of the, the standard card, and because of that, they had this interrogation thrown on or something. Okay, so, I think they're running just a little bit late. It's okay. It's all right. 15. Finally, based on the circumstances surrounding this interrogation, the defendant's statement was coerced and not freely voluntarily given. The defendant did not freely and knowingly waive her rights under Miranda. As such, the entire 2-hour interrogation should be suppressed. I don't know. It just doesn't really feel very strong to me. But, we'll see what the judge says. Judge is smarter than us. Let's see what he says. No coercion, stares above intelligence. I mean, and she came there with a list of questions, so obviously she wanted to engage in like a two-way conversation with the detectives, right? But boy, oh boy, she must have forgotten about that video that she took. Hi, Books with Sarah. How are you doing today? Hello. How's it going? Imagine, didn't read the whole card, gets a free murder. Well, even if the interrogation was tossed out, they still have a lot on Sarah. you know, because there's a lot of conflict. Because, you know, they're going to try to say that this is self-defense. Sarah's a battered spouse. But, I mean, there's a lot of other conflictions with what she said in the 911 call, the body cam footage. I don't know. We'll see. We'll see how they try to weave their way out of this one. All right. Should I just refresh it again just in case? Maybe that's why the judge is late, because the judge is probably reading what we're reading right now. The judge is like, oh, okay, we got this motion to suppress. Okay, it's amended. Let's read it. Let's see what's up with Mr. James Owens. I have refreshed the court's website. Let me. Anyone heard anything about the Alexi Treviso case yet? That's also another one that we're kind of just. Wait, did I have the wrong screen on the entire time? Oh gosh. I don't know if I did. Did I? Gosh, I'm just gonna pretend like I don't know. Did I have the wrong screen? The judge is in the chat. Defense strategy won't work with interrogation and trial. You think the defense is grasping at straws? Poor Sarah, always playing the victim. I wonder what the judge will say about this. It was due last Friday, 11:59. I mean, maybe Mr. Owens was affected by the hurricane, and maybe, you know, he emailed the judge and the staff and was like, hey, like, something happened. I need to extend it a little bit. But I don't know. I feel like, wouldn't they notate that on the court website? What is going on here? Who is holding this camera? I don't know what we're looking at. Hi, Chunky Lover. Oh my God, look at the cute little bubble souls. They're so adorable. You know what? Maybe, yeah. He said it may hand it to me before midnight. It may have been handed outside the system or delayed posting. That's true, Case. Yeah, it's possible because I forgot that they probably don't work on weekends. I don't know. Do you think the clerk of court works on weekends? We could probably look at their hours. Because it's possible that it could have been handed, or it could have been emailed, right? Maybe by Friday. And then whoever came in on Monday got it and then filed it. Possibly. So maybe the judge had like over the weekend to read it if he wanted to. Possibly. Yeah, Hurricane Helene is crazy. I watched the videos. I saw the pictures of all the flooding and stuff like that. Oh my God, it's horrible. There was one video that I watched where the flooding was literally like the height of the house. It's crazy. Bring your child to work day. It's a 10-year-old manning the camera. You know, do they still do that? Bring your child to work day? I remember it used to be called bring your daughter to work day. But I don't remember if people just end up just bringing their kids to work, son and daughter. What area is he from again? I think I saw Georgia. Some parts of Georgia and like North Carolina were really, really bad. Oh yeah, I guess we could take a look at it. What was the date? Let's see. Let's see. Where's the one that was from? Oh, here it is. This is the one that was filed on Monday, 4:39 p.m. Oh. I now certify I electronically file the proceeding with the clerks of clerks using the e-portal system, which I understand will send a notice of electronic filing. Oh my God, I can't see this. To the office of the state attorney on this 30th day of September. I mean, it seems like he did it on the 30th. The judge will say something if it's an issue. I feel like the state prosecution is just like, yeah, whatever. Come on, guys. Let's just get this trial done. Jesus. Yes, we're on day 6. How do you guys I heard I think if T-Mobile is out too. So like anyone that has like a T-Mobile service, I heard there's no service down there. Yeah, the last time I remember we had a really bad hurricane was, I think, Hurricane Sandy. It was a long time ago. Was it 20 years ago already? It was like Hurricane Sandy, and I think we didn't have electricity for about a week. I'm in central North Carolina. The west of you is destroyed. Yeah, because usually you think of like, like hurricane disasters. I usually think about like the coastal area, but it seems like there's a lot of damage in like the inlands as well, right? She said she paused when she saw Nicole with a Q in there and thought, there's no way. Sounds like you're raised a smart young lady. I told Grizzly to come here too. The case is interesting in that there is a question of, can a failure to act be a murder, which seems obvious but isn't well articulated in the law, it seems. My brother got his power back yesterday and is in Spartanburg. Sandy was awful. I'm in New Jersey. New Jersey Shore, we got hit hard. Yeah, Sandy was rough. I remember I think was I in like middle school, I think? I was in middle school. The hurricane was very wide. We drove to Savannah, from Savannah to Alabama on Sunday, and it was devastating between Savannah and Macon, Vidalia. Oh, whoops, sorry. I should probably... Okay. I think they're just a little bit late today. The judge is probably doing some stuff. Or maybe Sarah Boone's transport hasn't happened yet, because I don't see Sarah Boone in here either. Should I refresh again to see if there's anything else on here? Sandy was like 12 years ago? No, I think it was like 20 years ago, wasn't it? Oh, wait, Sandy, Hurricane Sandy. Or was it Katrina? Ah, wait, maybe it was Hurricane Katrina. Maybe it was Katrina then. Let me see. Hurricane Sandy. Hurricane Sandy. Oh, 2012. Okay, Hurricane Sandy. Sorry, I think it was Hurricane Katrina. My bad. Hurricane Katrina in 2005. That's the one that I remember. Oh yeah, that was horrible. Sandy was in New York City. Sandy was 2012. Okay. I do remember Hurricane Sandy though, but not as much as Hurricane Katrina, because Katrina was when like we just did not have power. I don't think we had power. I don't think we had yeah, it was like cold water, no power, and then luckily we had those because we used to go camping back then. We would have those like little gas mini stove things, just make like, I don't know, ramen and stuff like that and hot water. Yeah, sorry, I'm thinking about Katrina. You're in Nashville, so I love going to the Asheville and the Appalachians for the quick weekend trips. Yeah, I was back in 2005. I remember here. Okay, now I think I remember Sandy now, because I remember hearing about this family who they had a power outage, but then they had a backup generator. But while the family was sleeping, the backup generator was like leaking gas into the house. And so I think there's this girl who was like, I think around my age. I think she lost her entire family due to carbon monoxide poisoning. It was like super fucking sad. I think she lost like her mom, dad, brother, younger brother. I was like super sad. I don't feel as old if you're in middle school in 2005. Not 2012. Yeah, not 2012. No, not 2012. I'm way older than that. It's crazy because some of my friends that I've been playing pickleball with, they're like talking about, because like some of them are high school friends, and they're talking about like when they graduated, and they're like, yeah, we graduated high school in like 2012, 2000. Like, I'm like, ooh, 2012, 2015. Ooh. Oh gosh. Yeah. Our gas detect our not gas detector, our smoke alarm went off randomly in the middle of the night, and I was super fucking paranoid. I was like, oh my god, is it carbon monoxide? Like, what's going on? But we research online, and apparently you can tell what kind of beeps there are. So if it's like 3 quick beeps, it's a smoke alarm. If it's like slow beeps or something like that, it's carbon monoxide. I forgot what it was. And I was like, why don't they just like have a little thing where it's like, like a voice thing, a voice activator, where it's like carbon monoxide poisoning, or like, oh, there's a fire. But yeah, it went off in the middle of the night, and I was like super paranoid. So I slept with all the windows open because I didn't want to die. Check your smoke alarm and the batteries. Yeah, the batteries was fine, because usually when the battery goes off, it's like that loud, it's like that annoying beeping sound that happens random, like every, I don't know, let's say like every like 20 minutes or something like that. This one was like just straight up the. At first, I thought it was our security alarm that went off, and I was like, "What the fuck? Is someone trying to break into our house or something?" And then when I was listening to even more, I was like, "Wait a second! It's our smoke detector. That's so weird." The voice would scare me even more. I think somebody was inside my house. So we upgraded our because apparently the smoke detectors have a lifespan of like maybe 8 to 10 years. So we changed it out. And now this new smoke detector will tell you if it's fire or carbon monoxide, which I'm like, yeah, that's better than having this beeping thing. And then you're trying to guess what's going to happen. I feel old if someone doesn't remember when they were where they were during 9/11 or weren't born yet. Oh man, I made a reference to something recently, and the person I was talking to had no idea what I was talking about. What was it again? Oh, was it an artist or something? They just had no idea. I was just like, oh gosh, I can't have a conversation with you. Bye. Oh my god, people not remembering 9/11 or weren't born feels wrong. Yeah, because like I think right now people who are hello Sarah Boone. Because people that were born in like 2000, I mean they're 24 right now. You know, if you're born in 2001, you're 23 right now. And Sarah's here. Do we have any hairstylists in the chat? If y'all were to style Sarah Boone's hair, what can you do with her hair? It's so short. Would you do like a little clippy, a little headband, braids? I was in my crib, baby crib, not my house during 9/11. I was in Spanish class. Yeah, we're in Spanish class. And then like I just didn't understand what was going on. But then do we have televisions? Gosh, I'm trying to remember if we saw what happened on the news because we didn't have phones, you know, like not smartphones back then. But I'm trying to remember if no, actually they wouldn't show that. They probably wouldn't show that in school, right? So maybe it was when we went home, we saw what happened on TV. A fade. Oh yeah, she's still wearing her jailhouse garbs. UK here, we left school for the day. I went home and see. Yeah, I was like maybe because I was like that would be kind of weird if the school showed it to us because we were like in middle school. I don't think they showed it to us. High school, I can see. A Karen bob would suit her. You know what's the worst hairstyle? Oh gosh, but maybe it's just the worst hairstyle because of who was rocking it. You guys remember John and Kate +8? Oh my god, Kate's hairstyle. Her hair was kind of like an anime character's hair, to be honest. You guys watched Naruto? Sasuke had this hair where it was like flat. The bangs were flat in the front, and then like the back would like duck out like this, like a little duck's butt. That was exactly what Kate had. It was like the Kate hair. How many lawyers does this make? Well, she's on attorney 9, 10, 11. Technically 9, but she has 2 other attorneys as well. Let me talk to your sensei. Okay, I think mullets are coming back in style because I've seen some YouTubers rocking the mullet. I still don't like the mullet though. I don't like the way it looks, but I feel like it's sort of coming back or something. Or maybe it's trying to make a comeback because there are some YouTubers that are rocking the mullet right now. Or maybe they're trying to be really creative with their hair and it just accidentally looks like a mullet and they haven't realized it yet. They are. Okay, so Northwests are becoming popular. I'm like starting to see them. Mullets should have been left back in the 90s. I will say though, there was this one person. Who was it? There was a YouTuber. He rocks the mullet pretty decently well. Like it fits his persona and it fits his style. How did the dentist go? Let's see. Oh, I did the cleaning. That was fine. And then me and the dental assistant was kind of arguing back and forth a little bit because she was trying to recommend me to do something. And I was like, no, I'm fine. I don't think I need to do it. She's like, no, but you have to know just in case, because sensitivity is not just about you having sensitive teeth. It's about maybe the roots could be damaged. I'm like, no, I'm the sensitivity only bothers me when I'm at the dentist. I don't know. We're like kind of going back and forth. And she was like really like, she was very passionate. But yeah, no, the dentist I go to is super cool. So they made me a night guard. And then when I got it, the night guard did not cover the front of my teeth. And I was like, ooh, no, I need a full coverage because I used to wear braces and Invisalign. And I was afraid that my teeth would shift back up again because my teeth actually would stick out a lot more. And if you don't wear your trays and your night guards and stuff, or your aligners, then sometimes your teeth can shift. And they're like, oh, it shouldn't shift. I'm like, no, I want to be sure, because I paid so much for the Invisalign thing and it starts shifting. I'm going to be really annoyed to have to do it all over again. But he was really nice, though. He just made me a new one and says that he'll cover it for free. Curtis Connor. That name doesn't ring a bell. I'm trying to remember. Okay, it was a YouTuber. I think they covered drama. Not true crime stuff. I think they covered maybe like a drama YouTuber. Kind of rocks a mullet, or maybe they do politics. I don't remember. If I see the YouTuber again, I'll let you guys know. I don't wear mine. My teeth shifted. Yeah, that's what happened. That's what happens. I know so many people in high school where their parents paid so much to get braces. And then, high schoolers, we don't want to wear retainers every damn night. And so right after getting your braces off, it's like, oh, I have beautiful straight teeth. And then you don't wear the retainers every night and your teeth just goes back to, being shifted. Maybe rock candy, depending on how bad it was before. So that I know people that are they're adults now, and then now they're like, oh crap, like I want straight teeth again. So now they have to pay out of pocket to do the Invisalign stuff. Maybe she wants highlights. Maybe she wants a new color. I need to go back to the dentist. I chipped the back of your front tooth somehow. Oh no. Were you eating something crunchy? The annoying part is this just happened to me when I was a kid. I would bite into something hard and then it would crack my filling. And then you would like eat something and you're like crunching on your filling. Oh god. Where are the ladies? I don't know. I don't know where the assistants are today. Maybe they're in the back desk. Maybe they're sitting somewhere else. Maybe they're going to be virtual. I have no idea. My tongue keeps finding it. Oh, so it's like a sharp edge. Oh, gosh. I'm so old. When I got my braces off, they cemented the metal bar in the back of my bottom teeth. A few years ago, it snapped and they wouldn't put it back on. They told me they don't do that anymore. Oh, they don't do that anymore? Because that's when I used to wear braces in in elementary school. Yeah, I thought that's how they do it. They cemented it on there. It was such an annoying process. And I remember I don't know, my dentist sucked. He only put 4 braces on there. Just 4 instead of doing the entire damn teeth. I don't know why. And I had it for 4 years. The guy was just trying to make money off of us. He was ripping us off. It was a really weird experience. And then we took it off because it was like, okay, this is not doing anything. And then I ended up having to get Invisalign when I was an adult. Who is Sarah going to giggle with during this hearing? She got James Owens there. Mr. Owens is there. Oh, I hope they're getting along. Do you think they're getting along? What? Did I miss the mouthing of I love you? I think I missed that. Oh, not the brace. Wait, it was a retainer? Oh, wait a second. The retainer was cemented? What? They cemented a metal bar in the back of my bottom teeth a few years ago. Wait, what? That sounds so annoying. Morgan Waller brought mullet back. Morgan Waller. Oh, I don't know if that name rings a bell. I don't think so. So I've been watching this new TV show. I don't know if is it new? I don't know if it's new or not. It's called Monsters with the Menendez brothers. Because I've never really known anything about the case. I just heard last year, I think they were trying to get a new trial or something like that, because apparently they uncovered new evidence about a letter that was written to a cousin or something. So like I like sort of heard about the case, and I found out that it was a pretty big case that was televised. I think it was like one of the bigger cases like OJ back then. And so I was like, oh, let's just watch this TV show, because the TV show seems pretty interesting. But oh my gosh, I kind of want to watch the trial now. I'm still in episode, I think like episode 4 of the TV show. It's so dark. Yeah. It's so disturbing because of how graphic the descriptions are. And I don't know. Yeah, it's like super dark. It's very, 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 very disturbing. Oh, there's a new state response. Okay. Well, since we're waiting here, let's see what the state says. The defendant's case law submitted on September 30th regarding motion to suppress filed on September 24, 2024. State's response. Oh man, we love these last minute stuff. But I mean, the state had to, right? Okay, the defendant filed a motion to suppress statement on September 24, 2024 without citing any case law to support her decision. On September 26, the defendant submitted cases to their court regarding her motion. So 2 days afterwards. The 26th was what day again? 26 was last Thursday. Okay. On September 30th, the defendant filed additional case law with the court. These cases appear to involve issues outside the four corners of her motion to suppress statements. The state objects to any additional claims being raised at the hearing that were not specifically pled in defense motion. State v. Christmas and Vera v. State in the first of these cases. In that case, while not actually having a video surveillance of the defendant committing a crime, the police threatened to seize his truck 3 times, alleging that they did. The detectives in this case never said they had evidence they did not. And the defendant declined viewing the video she made while the decedent was in the suitcase, asking to be let out. Wait, hold on. In that case, while not actually having any video surveillance of the defendant committing a crime, the police seized the truck 3 times, alleging that they did. Detectives in this case never said they had evidence they did not. And the defendant declined viewing the videos she made. Oh, ah! Ouch. Oh, we're starting. We're starting? Should I keep reading? I recommend you guys turn down your audio until they get their audio stuff in order.
James Owens for Sarah Boone.
I do.
Good afternoon, everyone. Ms. Boone, good afternoon. If you could please state your full name and date of birth for the record for me.
Sarah Boone, 10-10-7-7.
Okay, we're here on several different matters, including a motion to suppress, specifically the motion to suppress defendant's statements at OCSO filed September
Okay, I think it's all good now, y'all. It's all good now.
24, 2024. The amended motion to suppress defendant's statements at OCSO filed September 30, 2024. And then just what was filed this afternoon at 2:35 p.m., defendant's second amended motion to suppress defendant's statements at OCSO. State, have you had the opportunity to review the second amended motion?
Yes.
Are you ready to proceed on that today? Okay. Are there any housekeeping matters we need to address from the state side of the ledger?
Not on that motion.
Okay. Any housekeeping matters on your side of the ledger, sir, with regard to those motions to suppress?
No, sir, Judge. I believe we've got 2 detectives outside to testify, and we've also got the custodian of records from the Orange County Sheriff's Department relating to the Miranda card and the policy and procedure.
Is that a valid argument that you're still embarking on this afternoon based?
Is that a valid argument? So he would talk. I don't know if you guys can hear him. It's really low. I don't know. I guess, because he's standing up right now. It's not talking to the microphone. He was talking about having an issue with getting the Miranda card from the Orange County Sheriff's Office. And the judge was like, okay, is that a valid argument that you still want to argue?
Based on what's in your second amended motion?
Yes.
Okay, so the sufficiency of the Miranda waiver is still at play?
Yes.
Okay, all right, thank you, sir. With regard to the other motions that were set for today,
Close. Makeup. Hair.
and I have reviewed the state's motion to strike, and I have reviewed all the case law authorities that you all have provided to me as well. With regard to the defendant's motion for hair, cosmetics, civilian clothing without restraints for trial, Mr. Jay, do you have any position with regard to the restraints at trial portion of that motion?
I believe the law of the case has already been settled on that issue.
Okay, all right, we'll entertain argument when we get there. And I've also reviewed the state's request for protective order filed September 30, which is also set to be heard this afternoon. With that, we'll begin with the motions to suppress. State, you can call your first witness.
Judge, I'm not objecting to the authenticity of whatever it is he subpoenaed. I've been getting some of the documents, Orange County Sheriff's Office General Order 711. I don't see any need to belabor the custodian of records sitting around. Was there something else? Was there actually a Miranda card?
Yeah, if you look in the very back,
Okay.
if you look in the very back,
Okay.
you see the Miranda card, the last page, and the neck of the last page.
Yeah, there's no need to keep the custodian of records around for authenticity. We still have our objections.
Okay, all right. Can the custodian then be released by virtue of the state's stipulation as to that, those records?
Yes, can I go tell her she can?
Yes.
Oh, while we wait, let me continue reading this then. Almost done. We got another paragraph to go. In that case, while not actually having video surveillance of the defendant committing a crime, the police threatened to seize his truck 3 times, alleging that they did. Detectives in his case never said they had evidence they did not have. The defendant declined viewing the video she made while the decedent was in the suitcase, asking to be let out. There was never any threat of the police taking any action or inaction based on what upon she told them. The case is inopposite. The defendant next submitted Johnson v. State, while law enforcement specifically asked the defendant if at some point somebody gets enough when they have to do something to defend themselves. The defendant stated, "I would just flee, and I don't know if you, ... There was never any suggestion, as there was in Johnson, that a self-defense claim was her only way out, much less that she would not go to jail if she claimed self-defense. In fact, the defendant repeatedly and adamantly denied there was any problems that night, so Sarah Boone, and denied that she did it intentionally. 5. While the defendant was questioned about how much she had to drink the night of the homicide, she said that she had a reason she did not remember filming the decedent, asking to be let out of the suitcase because of her drinking alcohol. There was never any suggestion by law enforcement that involuntary intoxication was a defense or that things would be better if she had admitted that she was intoxicated. In fact, the defendant continued to insist that she was not intoxicated despite having a blacked out and not remembering filming what she said to the decedent while he begged her to be let out of the suitcase. 7. Therefore, these arguments, while outside of the 4 corners of the motion to suppress, would not be allowed for the court to grant her motion to suppress either. Okay, back.
That's pertinent to the motion to suppress. The court has reviewed the entire video. With that, State, you may proceed.
Oh, he watched the entire video.
State would,
The interrogation.
ask the court for the clerk to mark A for identification of the
Okay, we're marking right now.
Received into evidence without objection to States 1.
So the judge has reviewed the 2-hour interrogation video.
Good afternoon, ma'am. Could you state your full name for the record and spell it for us?
Yes, it's Chelsea Capsule.
Capsule.
H-E-L-S-E-Y.
Oh, I knew I'd been pronouncing it wrong the entire time. I'm sorry.
Last name is K-O-E-P-S-E-L-L.
Thank you. Counselor, your main court.
Thank you. Where do you work, ma'am?
The Orange County Sheriff's Office.
And what do you do for Sheriff Mina?
I am a homicide detective.
How long have you been a homicide detective?
Over 6 years.
So, just usually law and crime, they just, it's a little bit rough in the beginning, but they'll fix their audio soon. I'm sure it'll be fine. Just give them a moment.
What's your total experience with the Orange County Sheriff's Office in terms of years?
I am going on 12 years.
Any prior law enforcement experience prior to joining the Sheriff's Office? And in the homicide unit, how is it that you get notified that you shall be the lead investigator on a case?
So for this case specifically, my team was on call that week for homicides. And so the deputy on the scene to notify the call center to notify the on-call homicide.
All right, and is it fair to say that you guys have 3 teams of 4?
Yes.
And each of the third weeks you will be on call?
Yes.
And then through some
They need to turn her microphone on because her voice is being picked up by a different microphone that's not even near them.
other random distribution, it's determined who of the 4 will be the lead?
Correct.
And it was your turn to investigate the death of Jorge Torres?
Yes.
And you were notified of this on February 24th of 2020 in the afternoon?
Yes.
About what time were you notified?
I would have to look at the CAD sheet to recall directly, but I would assume within 30 minutes to an hour of deputies being on scene.
All right, and do you go to the scene first, or do you do anything else?
For this particular incident, I got my partner, Detective Scott Lowen, and we headed out to the scene.
All right, and when you got to the scene, what did you do?
I met with the deputies there, and they kind of just briefed me on what was going on and what they responded to.
Did you do a walkthrough of the scene?
I did, yes.
And then was a search warrant drafted for the residence?
Yes.
And later executed?
Correct.
Did you have any contact with somebody identified to you as Sarah Boone on the scene?
Yes,
Do you see Sarah Boone in courtroom today?
I do.
Can you point out where she is and what she's wearing?
She's over here on my left, and she's wearing blue.
May the record reflect she's identified the defendant.
Record will so reflect.
When did you first have contact with her?
If I'm not mistaken, she was outside of the apartment when I got there. So once I spoke with deputies, I then went and introduced myself to her.
All right, and did you ask her any questions at this time as you guys are standing outside of the residence?
Not like detailed questions about like what happened, because I've already was told by deputies what she had told them. So it's more just to like introduce myself and to let her know, we're doing a search warrant and the procedures of how we do things.
And when you respond to a scene, do you respond in plain clothes?
I do, yeah, like business professional.
Like what you're wearing?
Yes.
And when you made contact with her outside of her residence for this first contact, were you alone or was your partner Scott Lowen with you?
I believe Scott was with me.
And was he also similarly dressed in business casual?
Yes.
All right. And so how long was this initial interaction with Ms. Boone?
Not long. Maybe a couple minutes to a few minutes.
Okay. And this was out on the sidewalk in front of her home?
Yes, if I'm not mistaken, she was at a neighbor's residence, like sitting out on their like front porch area.
You recall what you asked her in this initial contact?
Do I recall what?
You asked her?
No.
Okay. So it was just a couple of minutes that you were there with her?
Yeah.
Okay. And then what do you do after your first contact with her?
So once I did my walkthrough, we decided to go with a search warrant for the scene. So that was written by somebody else, and then once that was executed, we went in there further with CSIs, and then we talked to Brian Boone, which was the ex-husband, and then I believe we then sat Sarah into our unmarked vehicle and had a conversation with her.
Was that conversation in the unmarked vehicle recorded?
Yes, audio recorded.
And can you describe this unmarked vehicle for the court?
At the time, I was in an unmarked Pathfinder, so it was like gray in color, didn't look like it didn't say like law enforcement or police or anything on the exterior, and there were lights like inside.
Where did everybody sit in this Pathfinder?
I sat in the driver's seat, Sarah sat in the front passenger seat, and Detective Scott Lowen sat in the back seat.
Did you have any conversation with her about the facts of the case or your investigation that wasn't recorded inside the car?
No.
And that was all recorded and turned over to the state attorney's office?
Yes.
And you announced the date and time of the start of this interview on that recording, did you not?
Correct, I did.
Okay. Is it fair to say that it had been about 3 or 4 hours since the initial call out for a 911?
Yeah, I would say, yeah, because I believe we started interviewing her right before 5 p.m.
And is there any particular reason for executing the search warrant and speaking to another witness or witnesses prior to interviewing Ms. Boone?
Just based off the situation and what was happening.
Okay. Is it in any way unusual to gather evidence before talking to the last person to see a decedent alive?
No, of course not.
Okay. At some point during this day, which was February 24th of 2020, was her cellular phone device collected?
It was.
And when was that?
That same day.
I mean, when time-wise in relation to talking to her?
Well, I noticed the phone was in the kitchen area, but I didn't touch anything until CSIs documented everything, photographs, and so I don't think I really touched it until after I had talked to her about going through it.
All right. And ultimately, was she placed under arrest on February 24th, 2020?
No.
After she got out of her car, was she free to remain on the scene or free to leave?
Yeah. Not go back in her house, but yeah, she was able to leave.
Prior to that, had she been detained and requested not to leave the scene?
One more time?
Prior to your interview with her in the car, had she been asked or ordered to stay on the scene?
Not by me.
Okay. February 25th, was there a second interview conducted with you and Detective Lowen with Ms. Boone?
Yes.
Prior to this interview, had her phone been extracted by any member of the digital forensics team at the Sheriff's Office?
Yes, it had.
And had you reviewed some of the evidence on there?
Yes.
You had requested that Ms. Boone come down to the Sheriff's Office rather than you returning to the scene?
Yes.
Can you explain that?
It's more of a controlled setting for law enforcement. We were able to audio and video record at the sheriff's office, and she had mentioned that she might not be staying at her apartment, and so I didn't want to go to the ex-husband's residence where her potentially child was, so I just felt it was a more controlled setting at the sheriff's office.
All right. And when Ms. Boone arrives at the Sheriff's Office, who goes down to greet her and where?
It was not me. But she would have gone in through, we have two entryways, so either on the record side or on the opposite side. And she would have had to go up to a window and request that she was there to meet with me. They would call me. I would tell them yes, sign her in. And then, if I'm not mistaken, I believe Detective Lowen went down and got her.
All right, so you're describing two separate entrances that members of the public can come and go through?
Yes.
As opposed to separate entrances that might be in the back of your building where people are not free to come in and out of without a swipe card?
Yeah, the public doesn't have access.
All right. Now, in relationship to those two entrances, which I assume are on the first floor of the building, is that a safe assumption?
Yes.
Where are the CID or the Investigation Division's interview rooms?
They are located upstairs.
All right.
Second.
And is she allowed to just walk up to the second floor interview room, or does she have to be with an employee of the Sheriff's Office?
Hey, Ben.
She would have to be with an employee of the sheriff's office.
And your testimony is it wasn't you?
But I don't believe so, no.
Now tell us about these interview rooms.
We have 4 interview rooms that are audio and video recorded.
Okay. And they have, you said they're video recorded. Was the interview with Ms. Boone video recorded by the Sheriff's Office equipment?
Yes.
Was there any conversation about the case or the investigation with her that did not occur inside that room with the recording going?
No.
Okay. I don't have other questions of this witness.
Thank you. Any cross-examination?
All right, James Owens, come on up.
Detective, I'm James Owens. I met you outside just a few minutes ago, and you know I represent Sarah Boone. Detective, have you had a chance to review any paperwork related to this case prior to this hearing?
I have looked at my investigative report, and I have looked at some policies, but they were from current.
All right. Have you had a chance to view Deputy Kayla Rodriguez's body cam video prior to today?
I've seen it. I have not seen it recently.
Have you had a chance to review and listen to the audio interrogation that was in the unmarked vehicle that you did of Sarah Boone on the day in question?
Yes, I have reviewed that.
And have you had a chance to review the approximate 2-hour interrogation video at the Orange County Sheriff's Department?
Yes.
Would it be fair to say that prior to you asking Sarah Boone to enter this unmarked vehicle for this interrogation with Detective Lowen, that you did a preliminary investigation as to whether or not this was potentially a homicide?
Yes.
And you would have viewed the scene inside the apartment?
Yes.
And you would have spoken to Deputy Rodriguez about what she knew about the situation?
Yes.
And you would speak to Deputy Rodriguez about what Sarah Boone had said had happened?
Correct.
And did you talk to any other people there about the situation prior to speaking with Sarah Boone about the facts in this case?
Just Brian Boone.
Okay. And was that conversation recorded with Brian Boone?
Yes.
And would that have been in your squad car?
Potentially. I didn't listen to that interview. I don't
Okay.
know if we interviewed him outside or in my car.
Was he Mirandized?
No.
Okay. So although he was at the scene when y'all showed up, he was not considered a suspect or person of interest?
No.
At some point, did you determine that Sarah Boone was a suspect or person of interest?
At some point, yes.
Tell us when that happened.
The next day?
Okay, so at the time of this event, your initial appearance there at the scene, which I understand you must have stayed 4 or 5 hours?
Probably.
Okay. At that point, at no time did y'all consider Sarah Boone a suspect?
Well, it's difficult to the way you're asking, but she was the only one there. She's claiming that no one else was there. So what I was being told would mean that she was the only person of interest in that situation. But due to not having the autopsy results, we just interviewed her initially, got her initial statement, and then pending, once the autopsy was completed the next morning, was when I already knew I was going to meet with her again to discuss the autopsy results. So then we had another interview with her where she was Mirandized, and she went to jail later that evening.
While you were there on scene, I know at some point you saw her phone on the kitchen counter?
I did.
All right.
Or maybe on the microwave. It was somewhere in the kitchen.
All right, and at some point you went to Sarah Boone and you asked her for the password to open the phone.
We asked to go through her phone.
Did you ask Sarah Boone, can I have the password so I can go through your phone?
Yes, after she signed the consent form.
Okay, so not before? You didn't ask her before you asked her to sign the consent form, Sarah, give me the password to your phone?
Not that I recall, but why would I would normally have her sign the consent form first for her consenting to go into the phone and then gather the passcode or whatever it is.
Well, how would that have even come about then? I mean, how would you have approached her about signing the waiver to consent to searching the phone?
She called 911, so I told her that we needed to corroborate her story as to what occurred.
Okay.
And so to do that, I wanted to go through her phone.
All right, do you know about what time she signed the consent?
No, I don't think it requires a time on there. But it was when we were on the scene initially.
Was it prior to her interrogation in the unmarked vehicle?
Yes.
And after she signed the consent, your testimony is you asked her for her password and she gave you her password after signing the consent to search the phone?
Yes, I didn't touch the phone until my digital came.
All right. You're talking about the digital investigator? And they have the ability to open up the phone and search the phone?
With or without a password, yes.
But y'all utilized the password that Sarah had given, had you not?
I believe so.
Okay. And do you know how long it took for the digital investigator to show up after you arrived?
Oh, yeah, she didn't come until later. I believe around 7 p.m.
Okay.
That's when in the CAD sheet it says she arrived.
And you know there were two videos on Sarah's phone.
After I spoke to Sarah.
I'm sorry?
After I spoke to Sarah?
All right, so what I'm gathering from what you just said is at some point you asked or directed Sarah Boone into your unmarked vehicle where you interrogated her. Is that correct?
Where we completed an interview? Yes, sir.
And your testimony is that you did not view the videos that were found on her phone, and I'm referring to the 2-minute video of George in the suitcase, and then some time went by, and I think there was about a 22-second video of George in the suitcase that Sarah took of him in the suitcase. Your testimony is prior to you putting her in your unmarked vehicle that you were not aware of those 2 videos.
That is correct, sir. I did not go through her phone until digital forensics came out and then went into her phone. And then she brought me over to her van to tell me about the videos and what she found.
All right, so your testimony is at the time that Sarah Boone was interviewed in your vehicle, that the forensic phone investigator had not arrived?
Correct.
Okay. Did you tell Sarah, I know we saw the audio once you get in the car, but did you talk to Sarah before y'all got in the vehicle?
Of course.
And did you tell Sarah that y'all wanted to talk to her and this was routine protocol?
Yeah, that I wanted to have a conversation with her, and once I had walked through the house and saw what I was working with, we would have that conversation.
Did you tell her that interviewing her in the squad car was routine protocol to your investigation?
I don't recall if I specifically said that, sir. This was 2020.
Okay. If she recalled that, would you dispute it?
Objection, improper question.
Sustained.
Your testimony is you don't remember saying that.
I don't remember specifically saying what. One more time. What is it that she claimed that I said?
Routine protocol.
I would not interview her, not in my unmarked car. So my routine protocol, sure, I would do that. I would
Okay.
interview her in a spot where no one can hear us.
And you would explain to her why you were doing that, wouldn't you?
Would I explain to her why we were sitting in my car?
Yeah.
Standing?
Yes.
No.
Well, you would have to tell her something.
I said, yes, we're going to go have a conversation in my car now.
Okay. And did she have any questions that you recall about what's this about? And you could have potentially explained to her that this is routine?
It was all explained on the audio recording.
Okay. But you agree you had a conversation with her before you got into the car with her?
Yes, I definitely directed her to get into the front passenger seat when we were going to talk in the vehicle, yes.
Okay. And you don't recall whether or not you said this is routine protocol to come into the car and talk to me?
Those words specifically, no.
Okay.
But I would have talked to her in the vehicle regardless. I would not have talked to her outside of my vehicle.
Is he trying to say that the reason why Sarah Boone claims that Detective Kepsel said it was routine protocol because they wanted to minimize that Sarah was going to be Mirandized? Because that was part of his motion, I guess. Like, oh, they're trying to minimize, Sarah Boone being Mirandized. Maybe that's where he's going with all this?
All right. Now, once inside the squad car, you were there with the other detective, Detective Lowen.
Correct.
Okay. And you read her the Miranda rights card, correct?
Yes, from my card, yes.
Do you agree that you didn't ask her the last question, number 9?
Objection, relevance.
Response.
Judge, we're here on a hearing on the issue about the interrogation.
But the case law that you provided to me, none of it stands for the proposition. Rand identifies the 4 things that need to be addressed. Not one of the cases talks about that issue of reading that language at the bottom of the card that is in the motion upon information and belief. This is what it says. So,
Yeah, that's where I was like, I felt like the case laws weren't specific. The one that he was providing to the judge, Mr. James Owens. I was like, I feel like it needs to be more specific to what he's trying to claim. All right.
how's it relevant for the card that is in the motion upon information and belief? This is what it says. So how's it relevant for the purposes of today?
Well, it's relevant because this is the policy of her department.
But
Judge,
what is the policy? But now we're getting away from the card to now the policy. There's nothing about the policy right now.
This is the exact same thing that happened a couple hearings ago where the judge and Mr. Owens were going in circles about this, and it wasn't going anywhere.
The question is about what the card says.
Okay. The card is the policy, and the policy is the policy. They're intertwined. They refer to each other. Our argument is that she did not waive her rights.
But
remain silent.
That's a different issue than what is on the card.
I understand, but it's a coercive question about her not doing that, which was the policy of her sheriff's department. She elected not to do that. She wanted a statement from Sarah Boone at the scene. She wanted a statement from Sarah Boone at the Sheriff's Department. She elected not to answer a question that the policy says read verbatim from the card. Why did she not want it? Our position is it was an attempt by this detective to coerce Sarah Boone into talking.
On February 24th or on February 25th?
On February 25th, this interrogation ties into that one. She
Wait,
used
I thought we're focusing on the 24th right now.
the same routine protocol that she used for the second one. The first one, she claims that my client wasn't a suspect, wasn't a person of interest. At the Sheriff's Department, I'm sure, I haven't talked to her about it yet, but I'm sure she's going to say, yes, she was a suspect. Yes, she was a person of interest. Yes, we had probable cause to arrest her prior to her giving a statement. But what she said in terms of routine protocol the day before was what Sarah was relying on when she said routine protocol, when she questioned the detective about routine protocol the very next day in the interrogation room. And for her not to give that question goes to the totality of the circumstances as to whether or not my client, Sarah Boone, actually waived her right to remain silent. If she understood her rights and then she consciously and freely waived her rights. She was not asked that question. She was not asked that question in the car. She was not asked that question. But that totality of the circumstances comes into play for the court to consider, this court or an appellate court to consider, as to whether or not that statement should be suppressed.
Any other response?
Judge, just like it's irrelevant what the Sheriff's Office policy is compared to what the Florida case law says about our right to not be compelled to give statements under our Constitution in the state of Florida, or the United States and federal case law and the state case law interpreting the United States Constitution, the policy is irrelevant, and the officer's subjective intent is completely irrelevant in a motion to suppress, just like it would be in a traffic stop under Wren versus United States. What matters is objectively what was spoken to the defendant, and I would ask that we honor the local administrative order and call people by their surnames and not their first names. What
You see that whip around? Mr. Owens is so fast to whip around. He took off his glasses. Playback.
to the defendant, and I would ask that we honor the local administrative order and call people by their surnames and not their first names. What matters is that the defendant was read what the case law requires. Anything about the policy, anything about the officer's subjective intent is completely outside of all the case law submitted by both the parties.
Last bite at the apple.
I'm sorry?
Last bite at the apple. Last bite at the apple. Any other argument?
Judge, we're talking about the totality of the circumstances, whether it was coerced or not. You can take any technique or a non-technique, something that you use or don't use, to establish whether or not it was coerced or not. The fact that she didn't read, do you understand the rights? Do you understand these rights, which is the form, the Miranda warning form? Do you wish to talk to us at any time? That's on the waiver affidavit. On the other form, which is the policies form, it says, do you understand these rights? And then the question number 9, do you wish to talk to us at this time?
Objections overruled.
Thank you. And you're referring to surname. What do you mean by that? You mean,
That means last name.
okay, what did I say? This detective?
Keep calling the defendant by her first name.
All right. Can I say Sarah Boone?
Either Miss Boone or Sarah Boone. That's
Okay.
fine. You may proceed.
Oh, gosh.
Have you had a chance to look at the standardized Miranda card issued by the Orange County Sheriff's Office?
No comment.
Do you agree that you did not read the Sheriff's Office?
Yes.
Wait, sorry.
Chance to,
And that's
Okay.
fine. You may proceed.
Have you had a chance to look at the standardized Miranda card issued by the Orange County Sheriff's Office?
Yes.
Do you agree that you did not read the 9 questions to her in your squad car?
All 9 questions is
Correct.
Wait, I thought we were already done with this. Objection overruled. Wait, what?
No, I did not read all 9 questions.
Do you know how many questions you did read to her?
8.
Okay. And the question you omitted is question number 9. Is that correct?
Yes, it's actually not on my Miranda card, but continue.
I'm sorry?
It's not on my Miranda card that I read from. You can continue.
She said it's not on my something card, something, something. I couldn't hear.
What do you mean by that? It was the card that you read, it was not on the card?
Number 9, no, not on my card.
Oh, she's saying number 9 was not on her card. That's why she didn't read it.
We have multiple Miranda cards at the sheriff's office, but yes, that is the in reference to the policy. Yes, that is the policy.
Well, somebody dropped the ball somewhere. Did you fail to get,
Proper question.
Sustained.
did you fail to get the most updated card, or how did that happen, that the 9th question was not on your Miranda rights card?
I've had that card since I started being a detective in sex crimes in 2013.
Have you become aware, as it relates to filing this motion,
I've become more aware, yes, that there's that card.
have you gone and gotten the updated card?
Objection, relevance.
Sustained.
When y'all took her phone, Detective, did you tell Sarah Boone that you would be returning to her apartment the following afternoon to give her her phone back?
No,
You did not tell her that?
no. I listened to all my interviews, everything that's been audio recorded. No, I did not tell her that. We had plans to meet at the sheriff's office.
All right, tell me what you understood the conversation was as it relates to her getting her phone back.
I'm sure she asked when she'd be getting her phone back, and I didn't give her a detailed timeline. I said that, I don't even know if I told her that I decided to write a search warrant on it because I don't need to tell her that. It's evidence in a crime. I'm allowed to take it, and so I took it, and I wrote a search warrant for it.
Okay. But you don't recall ever having a discussion with Sarah Boone about when you were going to return her phone?
Specifically returning her phone, no.
Okay. Do you recall her calling you later that evening on your cell phone? From her husband's phone? You don't recall that conversation? She called you later that evening?
Do you have documentation of the phone call?
I have her testimony.
Oh, okay. Well, I don't recall the phone conversation.
Excuse me?
I do not recall the phone conversation.
Because on his motion, he said that Sarah Boone borrowed Brian Boone's phone, and then I guess, was it in his motion, right? Not the state's motion. I think it was in his motion. And then used his phone to call the detective. And the detective was like, oh, I'm pregnant, tired. Like, can you come to me and meet me here instead to get your phone?
You said that y'all had some discussions about Sarah Boone coming to the station. Was that talked about the day of this event or the next day with Sarah Boone?
It was talked about before I left the scene.
All right. And did you relate to Sarah Boone that she needed to come to the sheriff's department the next day to retrieve her phone?
I don't know if I specifically told her about retrieving her phone, but she knew that I was waiting to hear about the autopsy results and that I would probably have more questions.
All right, so you believe you told her that night, I need you to come back, maybe or maybe not about the phone, but I may have some more questions for you?
Something along those lines, yeah.
Okay. And when was it that you actually saw the 2 videos from Sarah's phone? Was it that evening after the interrogation in the squad car?
I've already answered, but yes, it was after the interview.
All right, and was it while you were on scene?
Correct.
Okay. And did you attempt to talk to Sarah again about that at that time?
No.
Okay. And so did you let your detective partner know about the videos on Sarah's phone?
Objection, relevance.
Overruled.
Did you let your partner know about that evidence?
Standing next to me.
Okay. And did y'all discuss that issue?
Objection, relevance, work product.
Sustained.
Okay. At some point, y'all had to, were y'all working together, or were you making all the calls, or were y'all making joint decisions?
Objection, relevance, work product.
Sustained.
Ma'am?
There's no pending question at this time, ma'am.
At some point, did you form an opinion as to whether you had probable cause to arrest Sarah Boone?
Objection, relevance.
Overruled.
Yes, at some point I did.
Did you make that decision by yourself, or was it collectively made by others with the department?
Objection, relevance.
Sustained. You don't need to answer anything.
Detective, at what point did y'all, that next day, I think you had her coming in the afternoon,
I believe it was around 3 p.m.
did y'all work on trying to get the search warrant for the phone?
I got the search warrant for the phone, and I believe I submitted it that evening. I would have to look at it, though.
Okay, do you know what time the search warrant came back signed by the judge?
It's documented in my investigator report, but I don't know.
Okay. And would it be fair to say that you told Sarah to come in later that afternoon or the next day?
Yes.
Okay. And would it be fair to say that you worked on the case that entire day until Sarah Boone came in?
Yes, I attended an autopsy in the morning. That's why I asked her to come in at 3.
All right, and what time was the autopsy that morning?
It starts at 8, but I did probably get till 10. It takes quite a few hours.
Okay, and were you there alone with the medical examiner, or was there anybody else there?
I don't recall if Detective Long was with me or not, but yes, of course, there's doctors there.
Okay. And so, in terms of your determination as to whether or not Sarah Boone was a suspect, did she become a suspect after you watched the video, the two videos from her phone the day before the autopsy?
Objection, relevance. The custody is not disputed on the February 25th statement.
How's this relevant? If the issue is knowing and intelligent waiver, the sufficiency of Miranda and coercion, what does the formulation of probable cause have anything to do with anything?
Well, I wanted to bring out the fact that they had already made a decision before she came in for the interrogation on the 25th that they had probable cause to arrest her. So that if she, A, either didn't come in, they were going to go arrest her that day, or B, if she did come in and she exercised or invoked her rights to remain silent, that they were going to arrest her anyway, that they had already made a decision that she was the prime suspect, they had probable
What does
cause.
that have to do with any of the three issues that are raised in the motions?
It's whether or not she was in custodial interrogation, whether she was free to leave.
I don't know that that's being disputed by the state.
I think my response.
That's my understanding. The state's not disputing that there was a custodial interrogation, which is why, on February 25th, which is why Miranda was provided prior to that.
Judge, it was provided the day before, and she's just testified she was free to leave at any time.
Okay.
So Miranda was given on two separate occasions. She wasn't in custodial interrogation. Detective, am I right? The day.
Well, hang on. Before we ask any questions, let's deal with the evidentiary objection first. The objection is sustained.
Okay.
You may proceed.
All right. Ma'am, you would agree that when Sarah Boone arrived that afternoon for the interrogation, she was not free to leave?
She was not going to be free to leave.
Excuse me?
She was not going to be free to leave, no.
Okay. And so if she would have remained silent and exercised or invoked her right to remain silent, she would have been arrested anyway?
Correct.
And that was based on your investigation that you had the night before at the scene. And it was based on her statements that she had given you in the squad car. And it was based on the autopsy that was performed the next day that you were present for. And it was based on the two videotapes that you saw from Sarah's phone.
Objection, relevance. As to what the probable cause basis.
Sustained.
Yeah, I'm a little confused where we're going with this.
You had all that information before you began your interrogation on the 25th of Sarah Boone.
I had all what information?
All the information that I just related to you. Before you
Does she have her arms crossed?
began your interrogation of Sarah Boone.
I had all what information?
All the information that I just related to you. Before you began your interrogation of Sarah Boone.
On February 25th?
That's correct.
Yes.
And you would agree that you wanted to speak to her on the 25th?
Objection, relevance.
Overruled.
Yes.
Okay. And would it be fair to say that you wanted to get statements from her relating to the injuries to George Torres from the autopsy?
Objection, relevance.
Overruled.
Yes, I wanted to have a follow-up conversation in reference to what she told me the night before and in reference to the injuries that she failed to mention.
And you also wanted to question her about the two videotapes that you had found on the phone?
Objection, relevance.
Overruled.
Yes, I do
Okay.
want to show her the videos.
And you agree, in your opinion, the two videos, and the autopsy were inconsistent with the story she had given you in the squad car the day before?
Objection, relevance.
Overruled.
The videos, I'm sorry, repeat your question one at a time?
You would agree that the autopsy results and the videos that were extracted or taken from her phone recording George, those two pieces of evidence from your investigation were inconsistent with the statement that she had given the day before in your squad car?
Same objection for the record.
Overruled.
Yes.
And I believe that's ultimately the reason you arrested her, because of her inconsistencies.
Objection, irrelevant.
Sustained.
Now, you said you had a chance to review the interrogation video at the Orange County Jail on February 25th of 2020.
The Orange County Sheriff's Office.
The Orange County Sheriff's Department. And also, I believe the state attorney had it transcribed. Have you had a chance to read the transcript?
I have not read the transcription. I watched the video with the audio.
Okay, have you had a chance to look at my motion where the question and answers are typed out, at least the first minute or so?
No, I've not looked at your motion.
Okay. Do you recall?
No, like, would she really be reading his motion? Hi, Andrea. How are you doing today?
You saying to her, I'm going to have you sit in the green chair?
Objection. Best evidence is the recording.
He's right.
Okay,
Objection sustained.
okay.
Judge.
Do you agree, prior to reading Miranda, that you mentioned to her that you had received his autopsy and that you were going to read her rights again, but that we had to talk about that, referring to the autopsy?
Objection. Best evidence.
Sustained.
Do you recall making some comments to her prior to reading her the rights?
Objection. Best evidence.
Overruled.
Yes.
Is it the policy of the Orange County Sheriff's Department to make any statements to them about the interrogation prior to reading Miranda?
Objection. Relevance.
Overruled.
One more time?
I assume that's not the first time you've read Miranda to a suspect.
Objection. Improper question.
Sustained.
Let me go back to the first question then. Is it the policy of the Sheriff's Department not to ask any preliminary questions prior to reading Miranda rights?
Same objection for the record.
Overruled as relevance.
You would have to show me the policy that you're referring to, but I was not asking her any incriminating questions during that time. I was explaining to her the purpose of the interview.
Well, have you ever been, I understand you must have undergone some training on Miranda rights and how to interrogate somebody.
Objection. Improper.
Sustained.
How long have you been with the Sheriff's Department?
Since 2013,
How long have you been a homicide detective?
over 6 years.
Okay. Have you ever been trained or told to ask or not to ask any statements or any questions prior to reading Miranda relating to them talking to you?
Objection. Relevance.
Sustained.
Can you tell us if you recall saying anything to her prior to reading her Miranda?
I recall briefly talking about getting the autopsy results, and that I wish to have a conversation with her.
All right. Do you recall again reading her Miranda rights to her on video?
Yes.
Do you recall again omitting question number 9 on the standardized Miranda rights form for the Orange County Sheriff's Office?
Objection. Relevance.
Overruled.
I did not ask her question number 9.
Okay. Do they have a Miranda cards form in the interrogation room?
No.
So you would have had that on your person?
She looks like a homicide detective in a TV show. So, how's everyone's day going? How are you guys? You're doing good. Good to hear. He didn't know what a surname was. I think he was just confused because he probably didn't realize what he called Sarah in the courtroom. But the Mr. J's response was gold. A surname, a last name.
You may.
All right, what do we got here? Identification A. We got something here.
You recognize that document?
We
Yes,
recognize
this
that
is our
document.
waivers and affidavits.
This is the waivers and affidavits. Oh, sorry, the subtitles are there, but it barely picks it up.
Is that a filled out of waivers and affidavits?
He said, is that a filled out waivers and affidavit form?
It's filled out by me, but there's something highlighted that I did not do.
Okay. And was that form filled out as it relates to Sarah Boone?
We're talking about just this top, right?
Yes.
Okay, I'm sorry. Does it what?
Does that form, is it filled out as it relates to Sarah Boone?
In the case, yes.
Is that her signature below?
Yes.
Did you see her sign it?
Yes.
Is that your signature below?
Yes.
And is that the consent for the phone?
The consent to search, yes.
On that form, is there also the Miranda warnings?
Yes.
So the consent to search for the form.
That is a form that's standardized by the Sheriff's Department?
Yes.
And you did not read a Miranda from those rights?
From this piece of paper,
Yes.
that's audio and video recorded, no.
Okay, you would agree that there's 9 questions on that Miranda, do you know?
Yes.
Judge, I would like to offer this.
Same objection
Was he not able to attach his form to his motion to suppress?
to the relevance. As far as it being a consent to search her phone, we're not disputing that she was in custody on February 25th, 2020, when she gave a statement to the detectives. And again, under the case law, there's no requirement for this question 9. Under any state case law regarding the Florida state constitutional right to not be compelled to testify against oneself, nor any federal or state case law regarding the United States Constitution, the Fifth Amendment applied to this state through the 14th Amendment that requires that question to be read. It does not go to the totality of the circumstances of the voluntariness of her waiver of her Miranda rights.
Your response.
Judge, obviously we disagree.
Then where's the case that supports that? Because as I addressed previously,
Yeah, obviously.
Miranda rights.
your response.
Judge, obviously we disagree.
Then where's the case that supports that? Because as I addressed previously, I read all the authorities. I mean, State versus Owens, State v. Thomas, Powell from the United States Supreme Court, which reversed a Florida Supreme Court decision, all talk about what's required by Miranda. And that question number 9 that you're focusing on isn't included in any of those.
I understand that, Judge.
The right to remain silent, the right to an attorney, before and after questioning. If you can't afford one will be provided to you. Everything you say can and will be used against you. Those are the things that Miranda highlights. That Miranda opinion itself says that. So what does question number 9 have anything to do with those things if the state case law and the federal case law, including...
And the judge has asked this many times already, not in just today's hearing, but in the previous hearing as well.
Anything to do with those things if the state case law and the federal case law, including but not limited to Miranda itself and Powell, and then the state case law of Thomas and Owens, all of which were provided either by yourself or by the state. Identify what's required, and that's not one of the requirements.
She has a duty to read the rights.
But they were.
I want to finish my argument.
Okay.
She has a duty to read the rights. She has an obligation to ensure that Sarah Boone understands her rights by asking that question. Do you understand the rights I've just read? And then there must be a waiver. Yes, I understand the rights, and I agree to speak to you now. So for that to be freely and voluntarily given, that statement, there must be a conscious waiver of the rights. The problem with the detective is she reads the rights, do you understand the rights, and then she goes right into questioning. She goes right into questioning without saying, do you
Today's going to be a long hearing. We're only talking about one of the motions so far. We still have 2 other motions after this.
agree to speak to me? Understanding your rights, do you agree to speak to me now? That goes directly to whether or not it was freely, voluntarily, and knowingly given, the statement. And whether that
The judge is going to be like, okay, where's the case law? Where's the case law? Where's the case law? Where's the case law?
waiver was. So under the totality of the circumstances, I think that evidence is relevant. It's the policy of the Sheriff's Department. Obviously, she had an old Miranda rights form, but she failed to read what we perceive as a critical question, and she's going to testify about what she perceived at the time that the detective failed to read that question and how it ties into the case. I understand that all they have to read is those 4, but I think under the totality of the circumstances standard that this court has to apply, that should be a consideration the court should consider. I know
All right, y'all heard that. Sarah Boone's going to testify. We heard it from Mr. Owens.
it was an honest mistake. She had an old card, but still, I feel like it should be considered in your decision.
Anything else, Mr.
Feel
Chair?
like.
It's essentially the defendant stating that they want to make new case law.
I'm going to sustain the objection as relevance by virtue of the decisions in Thomas 351, 7th, 3rd, 197, and Owens 41, 7th, 3rd, 352. There's, it's not relevant as to what the questions need to be asked for the purposes of whether a sufficient Miranda waiver was given.
Do you agree, Detective, that after you read
Dude, Mr. J, so spicy today, Mr. J. He's over it too.
There's, it's not relevant as to what the questions need to be asked for the purposes of whether a sufficient Miranda waiver was given.
Do you agree, Detective, that after you read her those Miranda rights,
Hello? Oh, no! No! What's going on? We broke it. We broke it. It was just getting so good. Oh gosh. Even the court streaming game. We're back, we're back, we're back.
you would agree the situation on the 25th, when you were reading her Miranda and about to question her, was different from the situation the day before when you read her Miranda in the squad car?
Yes, I had more evidence.
That was without the autopsy. That was without
The
the
phone.
2 videos from her phone in the squad car.
Yeah, I did, at the time of the interview, yes.
And in the squad car, she was free to leave.
I mean, I didn't tell her she was free to leave, but I mean, if she didn't want to talk to me, she didn't have to talk to me.
Okay.
I think it's possible that the news camera that was set up, I think they didn't realize that someone was going to go up to the witness stand and testify, I guess, maybe, and that's why they didn't have the microphones pre-activated. I mean, I'm assuming maybe that's just what happened.
That's all the questions I have at this time.
Thank you. Any redirect?
No, thank you.
All right. Can this witness be released?
I'd like her to stay.
All right. Subject to recall. Thank you.
She's like, oh.
State, you may call your next witness.
No additional witnesses or evidence on this issue, Judge.
Okay. All right. Anything from your side of the ledger, sir?
Judge, I would like, you stipulated to the introduction of the card.
No, I don't object to the authenticity.
All right, Judge, I would like to introduce maybe more cases of exhibit.
Mr. Owen's going to introduce some exhibit. Maybe the card? I thought we already introduced the card in. I could barely hear.
Just that one.
What is it that's been marked as Defense Exhibit B?
All right, so Defense Exhibit B. State, no issue with policy card, not disputing the authenticity of it.
Any objection?
Same objection. It's irrelevant.
Is it the form as of now, or is it the form as of 2020 when the... Okay.
Oh, is it the form that he's
Can I see
introducing
it
to the
for a moment,
exhibit?
please?
Okay.
Thank
Take
you.
the form.
Any additional argument with regard to the state's relevance objection?
Same argument.
No, I'm sorry, Mr. J, I wasn't specific enough. Mr. Owens, to you. Any additional argument?
Same arguments I've made.
All right, I'm going to sustain the relevancy objection for the same reasons the court articulated previously.
All right. No exhibit coming in. Maybe a different one?
And Mr. Owens, you had one additional exhibit as well?
This is a composite exhibit, Judge. It's the policy of the Sheriff's Department. And it's a general
You think he's giving her a little pep hug since they're feeling a little defeated right now?
Do you know what page specifically those policies are on?
Page 14 of 22. And I'm going to give you 2 more pages.
Is it beginning of paragraph 4, waiver of constitutional rights?
Yes.
Okay, I've read pages 14 and 15.
All right, Judge, and then you go to 13 of 28.
13?
13, well, it's the next,
Oh, there's 2 different sets. It's a
Split up.
composite. My apologies.
it's split up.
Got it.
13 of 28 at the bottom, P. And then it goes on to the next page, 14 of 28. Specifically 2A on 14.
Anything else?
No other argument, Judge,
Okay.
other than what we've talked about.
Anything further?
Same arguments.
Okay, all right.
Irrelevant.
I'm going to overrule the objection as to relevance as to what was pre-marked as composite C, and that'll be received into evidence. Over objection is states 1. I'm sorry, defense is 1.
Okay, so are we going to work on the other 2 motions now?
Any further witnesses, evidence, or testimony, sir?
Judge, I'd like to call Sarah Boone.
Ms. Boone can approach the podium.
Oh, when he said she was
She was
gonna
previously sworn at the
testify,
beginning.
Today. Got it.
Judge, I'll be here.
Yes, sir. Hang on, the deputy's got to move her.
I thought he meant in trial.
Ma'am, you've already been sworn. Counselor, you may proceed.
Ma'am, would you please state your full name?
Sarah Boone.
Well, you're going to have to speak up or move the mic.
Sarah Boone.
Yes.
Where are you currently housed?
At the Orange County Corrections Department.
Have you been there since February the 25th of 2020?
Correct.
Was that the date of this interrogation that we're here for on this motion?
Yes.
All right. Let me take you back to the morning of finding George Torres in the suitcase. You called 911?
Yes.
Is it true that Detective or Deputy Kayla Rodriguez of the Sheriff's Department arrived?
Yes.
What mental state did you have at that time?
I was very confused. It was very hazy. I didn't understand the monumental amount of people that were there and what they were doing with taking things from my home. I was worried about my dogs. I was worried about my son. I was in shock. I was traumatized by the situation and then trying to focus on everything that was going on at my home. I was hungover. I was still, I believe, intoxicated to a degree.
Objection, Judge. Move to strike. This is outside their motion to suppress. They have not made any allegations that her statement was involuntary because of her mental state or state of intoxication.
Response.
She said she was worried about her dog. She was worried about her son. Did y'all hear her talk about her dogs, her son at all in the body cam video? No, it was like, oh my God, I need my cigarettes. Oh my God, I'm thirsty. Oh my God, I need my Dr. Pepper. I don't remember hearing her saying anything about her dogs, anything about her son. Just saying.
Response.
Judge, we're talking about, I'm just getting some preliminary information.
But
Her interrogation is the next day.
the state has an obligation.
There's no jury here. There's no jury here. We don't need this. Just go straight to the point. Let's go.
Case law cited by the state requires
Is the next day.
the state has an obligation, and the case law cited by the state requires specificity in the motions, so it's not a game of 20 questions and a surprise.
Okay, this is the day before the interrogation.
I understand that.
We're not talking about an
But are
intoxication.
you going to be arguing anything in conclusion as to what happened on February 24th led to any coercive or coercion behavior on behalf of the Orange County Sheriff's Office on February 25? Are you going to bootstrap or link any of those things together?
The interrogation in the squad car and what was said to her prior to getting in the squad car that relates to what she said about it being routine protocol, yes.
All right, I'm going to sustain the state's objection.
Relating to the intoxication?
Yes.
Okay.
It wasn't raised in any of the three motions that have been filed.
Judge, I didn't ask her that. She volunteered that.
I understand it.
Okay.
Objection sustained and it's stricken.
So you didn't prep her?
All right. Did you speak to the deputy about what had happened?
Yes.
Okay. And then, were you asked to stay on scene?
By both, yes. By both detectives, yes.
Okay. How long did it take the detectives to arrive after you had spoken initially with Deputy Rodriguez?
It was not right away. I don't know specifically, but it was not quickly.
Okay. Did the two detectives, when they arrived, did they take over the investigation?
It was my understanding, yes.
No foundation for her to conclude anything.
Sustained.
At some point, were the detectives directing you what to do and where to go?
Yes.
Okay. Can you explain what the detectives told you as it relates to you getting in the car? Was the phone issue before the car?
Yes.
Sustained.
Let me ask you about the phone. When were you first asked about your phone?
From my remembering, it was once they arrived, one of the first questions that Hopesall asked me was if I owned a phone.
And what did you tell her?
I told her it was on the kitchen counter.
All right. And what happened next as it relates to the phone?
I believe that it was brought to her with someone else. I don't remember.
Sustained.
I believe.
What was the next thing that you were told or talked to about as it relates to the phone?
Unlock it.
Who told you that?
Detective Copsell.
How did you unlock it?
She handed it to me, and I unlocked it.
How do you unlock your phone?
It was with a passcode.
Okay. And when you unlocked it, did you give it back to the detective?
I did.
All right. Did you ever see the phone again?
I did not.
Okay. After that incident, was the next time you were spoken to by Detective Copsell was in relation to the interview in the squad car?
Yes, she told me I needed to go with her and Detective Lowen to her unmarked vehicle.
And did she tell you anything about what was going to take place once y'all got inside the vehicle?
That she was just going to be asking me general questions.
Was there ever any mention about normal protocol?
Not that I can recall.
Okay. What about once you got in the squad car?
I don't recall the squad car.
Okay. And that was recorded for the court to consider. And so she read you your Miranda rights?
Yes.
All right.
Did you understand your Miranda rights?
Did you answer the questions?
I did.
Did they ever indicate to you that you were a suspect?
No.
Did they ever indicate to you that you were a person of interest?
No.
Did they ever refer to the videos that you recorded on your phone from the night before?
No.
Were you ever questioned about those videos at the scene?
I was not.
All right, after they finished interviewing you in the unmarked vehicle, were you allowed to get out?
Yes.
Were you allowed to leave the scene at that point?
I was instructed by both to not.
Okay. And how long did you stay on the scene?
The entire time.
How long was that? How long did it take before the investigation was completed?
10 hours or more.
Okay. At some point, did they all leave?
Yes.
And at some point, did they tell you they were finished with the work there at the scene?
Yes.
Okay. What did you do?
I went inside my apartment and gathered a few things, and then I went to my former husband's residence where my son was located.
All right, and how far was that away?
About 5 minutes.
How did you get there?
I drove
Okay. What was the reason that you wanted to stay over there the night?
because I was terrified of his family.
Now, later that evening, you were going to spend the night there with your son and with your ex-husband?
Correct.
And did you do that?
My son, yes.
All right. Later that evening, did you...
I mean, maybe she didn't have any friends or anything, but if you were terrified that George's family was going to come after you, would you really bring the danger to your son, though? Like, would you want to stay in the same place where your son was staying? Because couldn't they technically just, like, look on the white pages to see, you know, Brian Boone, Sarah Boone, you know, last associated address or something like that? I don't know. Maybe she couldn't afford a hotel or something, or maybe she didn't have any friends to stay with. Maybe she really thought that George's family didn't know where Brian Boone and her son lived, but I mean, I felt like you could just look that up.
You attempt to contact Detective Copsell.
I did.
And whose phone did you use?
Former husband, Brian Boone.
You said your phone had been seized,
Correct.
and you had consented to that? You signed a form allowing them to take the phone?
Yes.
Have there been any discussion about returning the phone?
Copsell told me she or Lowen or both would return back to my apartment to return my phone
And when did they tell you this?
before they left the scene.
And did they tell you they would return your phone where?
To myself at the apartment.
And is that what you understood they were going to do?
Yes.
Was there ever any talk about you coming to the sheriff's department the day of this event?
No.
All right, so later that evening, you borrowed your ex-husband Brian Boone's phone and made a phone call. How did you know Detective Copsell's private cell number?
She gave it to me before she left the scene.
And did you call her?
I did.
Do you recall about what time you called her?
I believe it was around 9:30 or 10 o'clock.
And that would have been on February the 24th of 2020?
Yes.
All right, can you tell us why you were calling her that night?
Before she left and giving me her personal cell phone number, she told me if I were to recall anything, or if I just wanted to talk to her about something regarding the case, for me to call her. So I took that to heart and felt very uneasy about how they left the scene.
Sustained.
Go ahead.
There's no pending question at this time.
Okay. You were concerned about the case and you wanted to call her?
Yes.
And did you talk to her?
Yes.
What did you say to her?
I told her, in all honesty, that I felt that she was trying to trick me.
You're relevant what her statement is.
Sustained.
Did you have a conversation about your phone?
Yes. I asked her.
Answered.
Overruled. You may answer the question, ma'am.
Did you call for a yes or no? She said yes, and now I don't know what's pending and how to object.
Did y'all have a discussion about your phone?
Yes.
Can you elaborate on that discussion?
She told me that I needed to come down to the sheriff's department because she was pregnant, and asked me if I remembered about when I was being pregnant, and it would just be a lot easier for her if I were to arrive at the sheriff's department to pick up my phone.
Was there any discussion about you being interrogated at the sheriff's department?
No.
Was your understanding the sole purpose of you going to the sheriff's department the next day was to pick up your phone?
Yes.
And the sole reason for the change in plans from them bringing the phone to you was because Detective Kopsel was pregnant and not feeling well?
Correct.
I mean, we're getting a preview of how she's going to testify in front of the jury. Yes, I was confused. I was really worried. I didn't know what was going on. Like the really soft voice. But Sarah, we've seen the letters. We've heard you in the body cam. We saw you in the interrogation. We saw how you are. This is like, I don't know. This is kind of like classic, like Amber Heard, like, yes, like, I was Johnny, and then blah, blah, blah. Like, when they're trying to portray that, like, there's like a soft, quiet, like, oh, harmless woman. I don't know, man. It's hard. It's hard because, we read the letters and all that stuff.
So the next afternoon, did you drive to the sheriff's department?
I did.
Tell us, when you parked your car, where you went, what happened?
I parked my car and left everything as regular in my car, and walked through the front door and went to the window asking
Like when Jodi Arias was testifying.
who I needed to see, and they, I guess, rang them upstairs, and Detective Lowen came downstairs, and I thought I was supposed to be picking my phone up over at a particular window, and he says, no, your phone is upstairs, so we would just like for you to come upstairs, and that's where you can pick up your phone.
All right, and so did he escort you upstairs?
He did,
How did y'all get upstairs?
in an elevator.
And what was he wearing?
Huh?
I believe he was wearing a red shirt along with his firearm and black pants
Oh, maybe
His
they were-
firearm was on his waist?
the entire time, yes.
Okay. So y'all got off the elevator, where did you go from there?
He brought me into a very small room, and they had me sit down, and then from there I had a list of things that I was going to ask them that I might need to do or that I could do.
Okay. So from the elevator, Detective Lowen escorted you directly into the interview room, and we've got the recording, the audio and the video. You didn't go anywhere else
No.
prior to that time. Was there any discussion that you made outside, any discussion between you and either detective about anything, the phone, questioning, anything before walking into that room?
No.
Okay. So directly off the elevator and walked into the interrogation room?
Correct.
And then we've got the video on that. Now, you and I have watched the video, correct? And you've seen the motion.
Are we still in the first motion? Yes, we are. We have 3 other motions to go through. And then also, why would the cop not have his gun? In Owens's motion, he was arguing that, oh, the officers had their firearms. Sarah Boone felt like she couldn't leave the interrogation room. I think that's why they're trying to highlight, oh, what was the officer wearing? Oh, he had a firearm on? Dang!
Motion, where I've referred to the questioning, where she asked you to sit down.
Yes.
You recall that happening?
Yes.
Did that refresh your memory watching the video?
Yes.
Do you recall her saying that she had received the autopsy?
Yes.
Do you recall her saying, I want to read you your rights again because we have to talk about that, referring to the autopsy?
Yes.
This was prior to you being read your Miranda rights.
Correct.
And she also said, we're not done talking about the incident. You recall that?
Yes.
And then she said, we just have to do it.
Yes.
How did that make you feel?
Sustained.
Were you trying to comply with the officer's demands?
Overruled.
In every way.
Were you trying to cooperate?
In every way.
Were you polite with them?
Very.
And when she said that, we just have to do it, you said, just like we did yesterday.
Yes.
And then you said, normal protocol.
Yes.
Is that what she had said the day before?
What do you mean?
Normal protocol.
Yes.
Had she said the same word? You said normal protocol to her.
I was reiterating to her what she had said to me the day before.
So she read the Miranda rights to you,
Except number 9.
except number 9. She read the rights, and then she said, do you understand what I've just read to you? And you agreed that you had.
Yes.
But you were not read, having these rights in mind, do you agree to speak to me now?
Overruled.
I was not asked that question.
Is it fair to say that after she read the Miranda rights, and after she said, do you understand the rights that I've just read to you, that she read right into the questioning?
She did.
Oh, is it going to be like, oh, had she read the last question, number 9, would you have agreed to not speak to her? Or would you have not agreed to speak to her?
Correct.
So she never got the answer from you, do you agree to speak to us now?
I was never asked that.
The way that she acted, the things that she said, the fact that they had your phone, did you get the impression you were not getting your phone back if you didn't answer the questions?
Sustained.
She was in custody?
Yeah, that's been conceded by the state in their response that it was a custodial interrogation.
But she wasn't aware of it. She wasn't aware she was in custody.
What does her subjective perception matter?
Well, under the circumstances, it would matter. I mean, she didn't feel she was free to leave. She was in an enclosed, small space.
That all goes to whether or not...
She was being questioned by 2 lead detectives, homicide detectives. One of them was wearing a firearm. She was trying to cooperate as best she could. I think her position is that she was coerced into answering the question.
What does that have to do with coercion? Those are all factors that under remedial...
The judge interrupts, and then he wants to finish, but then when he's finishing, he doesn't really add any more value to his argument. And then the judge is like, has to listen to the entirety of his argument. And the judge just goes back to, okay, well, what does it have to do with anything? How is that relevant? I feel like we need to give the judge a shirt. How is that relevant?
Ramirez as to whether or not it was custodial.
Well, I know some of the factors are whether or not the interrogation actually happens in a police station or not, or whether it happens outside a police station. So just that environment alone.
That goes to whether or not it was a custodial interrogation.
Okay.
I'm struggling with the connection on that being noncompliance with Miranda, coercion, or the third ground of voluntariness.
Well, and I think it goes subjectively to her and what she was feeling, if she had a free choice or not, based on
subjectivity matter.
Excuse me, based on
subjectivity matter. under the case law.
Based on the circumstances that she was dealing with at the time, whether or not she felt she had a choice.
But what does her subjectivity have to do with that?
I believe it's relevant.
Objection's overruled. I'm sorry, the objection's sustained. I apologize.
Oh, gosh.
Did you understand you were not going to get your phone back until you answered their questions?
Objection relevant.
Sustained.
Did you have some questions for them at the end?
I did.
Did you feel like you had a choice in answering their questions?
Objection relevant.
Sustained.
Ma'am, that day, you came to the sheriff's department to get your phone?
Yes.
Did you know that you were going to be placed in custody?
I did not.
Did you know that you were going to be arrested?
I did not.
Did you know that you were going to be questioned?
I did not.
Were you trying to cooperate with law enforcement based on her statements that you have to talk to us?
Yes.
Overruled.
Were you there answering the questions because she confirmed that this was normal protocol?
That was my understanding, yes.
That's all the questions I have.
Any cross-examination?
Woo. Okay, cross with the state.
So that afternoon on February 24th of 2020, when Deputy Kayla Rodriguez arrived at your residence shortly after 1 p.m., you were under the influence of alcohol, correct?
Yes.
You were impaired by alcohol, correct?
I don't know as much as impaired means. It did affect, yes.
Okay. And that was consumption from the night before, correct?
Yes.
So you did not go to brunch that morning and have mimosas or anything else to drink, correct?
Correct.
And you consumed no alcohol in your home that morning, correct?
Correct.
So does that affect in any way your memory when you testify about the events that transpired between you and Detective Copesel that afternoon?
Oh my God, what a good question. Oh my goodness. What a golden question.
Home that morning, correct? So does that affect in any way your memory when you testify about the events that transpired between you and Detective Copesel that afternoon?
Ask one more time, please.
Did the alcohol have any effect on your memory of what happened between you and Detective Copesel that afternoon?
Now or then?
Then.
Did alcohol affect my conversation with her?
Ooh, this is how you know she got stuck. She's like, ah, shit. Because it's like, oh, can you ask the question again? Oh, let me ask the question out loud to myself real quick so I can stall and ask for more time and see what I can come up with.
Then.
Did alcohol affect my conversation with her?
There's a jury instruction that says a witness's memory and perception is pertinent, and I'm asking you, did the alcohol that you were under the influence of affect your memory or perception of the events that you've testified to today that you said happened on that afternoon of February 24th, 2020?
So did they affect? My answer?
Judge, I don't think she understands the question.
I don't.
She understands the question. She just realized that she kind of trapped herself in it. Oh my goodness. There was something else I wanted to say. Shit, I forgot. It's okay.
It's been asked 3 different ways.
So we'll leave it at you were under the influence of alcohol that afternoon, correct?
Judge, I think she said she didn't know what, she said that she had alcohol under the influence or impaired.
The objection is, the court does not entertain speaking objections. The legal grounds need to be provided. What are the legal grounds of your objection?
I know that she had said she didn't know what.
What are the legal grounds of your objection?
I'll withdraw.
All right, you may proceed.
All right. And you understand that you're charged with second-degree murder in this case, correct? You're facing a potential penalty of life in prison, correct?
I understand.
Do you understand that the score sheet minimum is probably about 22 and a half years?
I don't know.
Okay. And it is your desire to have these statements excluded from the jury's consideration, correct?
Judge, I would object to that.
Sustain the objection.
Your intent is to testify differently than you have testified in the statements in State's Exhibit 1, correct?
Regarding the
I would object to that. I'm not understanding what the question.
Mr. J.
Judge, a witness's bias is always at issue when they take the stand, and it's our position that her credibility for all the things that she has testified to today, that particularly the things in conflict with Detective Copesel's testimony, and the court, of course, in a motion to suppress, has to consider the credibility of the witnesses, and you are in the best position to do that. The appellate courts are going to be very deferential to you. It's our position that she's biased. She is charged with second-degree murder. She's facing life in prison. Based on the examination that both state attorneys and defense counsel and the state's expert witness today. It is the state's belief that she is intending to testify differently than she testified in the statements that she provided to law enforcement in State's Exhibit 1, and therefore she is biased in all the things that she's testified about today because it is her intent to get this statement, all these statements, or the statement on 225 thrown out so that she is not going to be cross-examined and impeached with it so that she can testify the way that she testified this afternoon.
Response.
Judge, I agree with the impeachment about being under the influence. I agree with the impeachment about what she's facing, that she may be biased because she's facing potentially life in prison. He claims 22 years on the low end. I agree with all that. We just got through at the jail meeting with the state's expert who evaluated Sarah Boone. I was present. The two prosecutors were present. It wasn't recorded. He can't be a witness now. If he's going to question her about what was said during that evaluation, then he's putting himself potentially to be a witness down the road. I don't think that's proper cross-examination about what she said there versus what she's saying here.
Anything further? Mr. J.
I am not specifically asking her what she said that was different, and obviously if I did and she testified differently, I would have to accept that answer. There's no way for me to extrinsically impeach her with that due to the brevity of the time frame that we have all been subjected to. But I do believe it's a fair question to ask her whether or not she intends to testify differently than her statements that are in State's Exhibit 1 and consistently with how she testified this afternoon, and that she understands it would benefit her if these statements are excluded.
So I'm going to sustain the
Someone said earlier, I don't think Sarah Boone knows is 22 years minimum. I don't know where it is. I just lost it, but I'm sure she does because when Mr. Owens was trying to go back and forth between the state and Sarah Boone in regards to like potential plea deal, I'm sure they gave her the facts. Like, hey, you're facing this. If you're prosecuted or if you're convicted, this is what happens to you. This is the minimum. This is the max you're facing. So I'm sure she's got to know. I'm sure she's got to know that. Yeah, and don't forget, feel free to like the stream if you guys are enjoying.
The objection based on how the question was asked. I'll allow you to revisit it based on how you did.
Her statements that are in State's Exhibit 1 and consistently with how she testified this afternoon, and that she understands it would benefit her if these statements are excluded.
So I'm going to sustain the objection based on how the question was asked. I'll allow you to revisit it based on how you just explained it to me.
You gave statements to an evaluator this afternoon, did you not?
I did.
All right. And without going into the details.
So Sarah Boone today was scheduled to have a eval. I think it was like a. Okay, so Dr. Julie Harper was the forensic psychologist that evaluated Sarah Boone. That was by the defense. The state also gets to hire their own expert to evaluate Sarah Boone as well, and that actually happened today. So I think that's what they're referring to.
Statements to an evaluator this afternoon, did you not?
I did.
All right. And without going into the details, would you agree that there are some differences in those statements as to what is in the statements you provided to law enforcement on February 25th of 2020?
Yes.
And you understand that I would be able to cross-examine you on giving inconsistent statements at trial if you take the stand, correct?
I understand.
And so you understand the benefit of this motion to suppress being granted?
Of course.
No other questions?
Any redirect examination? Okay. We can have Ms. Boone return back to counsel's table. While she's in the process of returning to counsel's table, anything else further from an evidence or testimony perspective from your side of the ledger?
No, sir.
Okay. Anything else from the state other than argument?
Just argument.
Okay. All right. Once Ms. Boone's seated, we can proceed with any argument. And as the court identified previously, I have reviewed all y'all's authorities that were provided. Mr. Owens, it's your motion, sir. You may proceed.
Dude, Mr. J. Got him. Got him. You said that you were impaired from alcohol the day before. Okay, and would that affect your memory between what happened between you and Detective Kopsel? Huh? Sarah was like, sorry, can you ask the question again? Oh, would it impair?
It's my understanding of the law regarding Miranda.
Star was like, I don't think my client understands the question that's being asked. Like, no, she understands. She just realized that she got herself in a trap.
It's my understanding of the law regarding Miranda. First issue is, was the defendant in custody, was the suspect in custody? Was it a custodial interrogation? We have agreed or stipulated to that fact.
It was.
We're referring to the 2-hour interrogation at the Orange County Sheriff's Department. Specifically, we're referring to about the first minute or two of that video. And I think under the totality of the circumstances, the court has to determine whether freely and voluntarily and knowingly given under the circumstances. Judge, law enforcement, after they get a valid waiver of rights that I'm not going to be silent, that I'm going to answer questions. Go ahead, ask me and I'll answer the questions. Once that happens, law enforcement is trying to get a confession. Law enforcement is trying to get admissions that they can later use at trial to impeach the defendant and convict him.
Yep.
The law allows law enforcement at that stage to use deception,
Yep.
to lie, to trick. We found the murder weapon. It's got your DNA on it. Your co-defendant has come in here and confessed and implicated you.
Okay, yep.
All those techniques, when it's really deception, they don't have the DNA, they don't have the murder weapon, they don't have the co-defendant, can be utilized to obtain a confession or an admission of guilt. But prior to Miranda, you cannot deceive. Prior to Miranda, you cannot trick. That right is fundamental. You cannot be compelled to incriminate yourself. You cannot be forced to talk. It's got to be free will and a choice. And so you can't seduce or coerce someone into giving a statement. And the law is clear. When that happens, we've got to punish law enforcement to correct that type of misuse behavior. It's illegal. So you got Detective Kopsel on the one hand. I got to read your rights. And you have a right to remain silent. But within a minute before, the detective is telling Sarah Boone, we have to do this. We have to talk to you. Now, that's confusing. That's deceptive. There's nowhere in policy that that should be allowed or is allowed. There's nowhere in the law that that should be allowed. It's actually illegal to tell a suspect, we have to talk to you. We just have to, before reading Miranda rights. That is an illegal statement. Sarah Boone did not have to talk to them about the autopsy. Sarah Boone did not have to talk further about what had happened.
Would it be different if the statement was reversed? If law enforcement instead said, you have to do this, you have to talk to us, would that make his argument stronger?
But that's the implication this detective gave Sarah Boone. It taints the Miranda that comes before it. Here's a law enforcement officer. I'm trying to cooperate. We've got to talk to you, but you have a right to remain silent.
Oh, true. We have to take the context of it. We have to reference the reading the rights. Yes. Yes, I do remember that actually. That was the context, wasn't it?
But the statement of we have to read you the rights was made before we have to talk to you. So your argument transposes those two things chronologically.
Why are we even having it? I mean, why even have the confusion? I mean, we're sitting here Monday morning quarterbacking, but Sarah Boone was brought up there under false pretenses. A traumatic event, she lost her boyfriend. I'm coming to get my phone. I've been tricked into coming up here to get my phone. And I'm sitting here having to figure out what to do about whether to talk to these people or not. And she's talking about my rights, but then saying, we have to talk to you. We just need to do it. And then she reads the rights. Right there within a few seconds of each other. That's improper, it's illegal, it's coercive. It forces this not to be a valid waiver of her rights under that circumstance, coupled with the fact that she came down under false pretenses.
Yeah, this is what happens when you run out of steam in your argument. You just keep repeating yourself.
Coupled with the fact she doesn't have the ninth question. If you think about it, okay, you got a right to remain silent, you got a right to a lawyer, those 3 or 4 questions, and then, do you understand what I've just read to you? I'm paraphrasing. But then Detective Kopsel goes right into questioning. Once Sarah says, yes, I understand, it's an acquiesce to authority. Okay, let me start asking her questions. The critical question is, having these rights in mind, do you agree to speak with us? That is the time of free choice. That is the time of decision for Sarah, to be given that opportunity. But the way I understand, Detective Kopsel had the autopsy. She had the blunt force trauma. Those were not questioned. Sarah Boone was not questioned about that. They didn't know about that until the medical examiner. So she had additional information that she wanted from Sarah Boone. She had the 2 videos from Sarah Boone's phone. She had additional information from the phone that was inconsistent with the statement that Sarah had given the day before. So sure, any detective worth their salt would want a statement. She'd already said we had probable cause. We'd already made our mind up that we were going to arrest her. If she didn't come, they were going to go get her. If she came and said, I want to invoke my rights, she was going to be arrested. They wanted to get some type of admission, confession, statement that they could later use, which they're trying to do now. But under the circumstances, the totality of the circumstances about how she was induced to come down there, about telling them that she had to talk, Judge, it was coercive. We would ask that you suppress the evidence.
Any response?
Mr.
The
J.
United States Supreme Court has said that confessions are good. They are good for society. It is good when guilty people are convicted. We stand by all the case law that we've cited, and you have reviewed the evidence from start to finish. Under the totality of the circumstances of that 2-hour and 6-minute statement that she gave to law enforcement, she knowingly and intelligently and voluntarily waived her Miranda rights. And under the case law, it was done perfectly fine. There is no requirement that that question number 9 get read. And as far as any credibility issues that are pertinent to the court's analysis, which the state would submit there is not, because we are conceding there was custody on February 25th, they are allowed to use subterfuge and deception to get somebody to come to the police station under the case law and authority cited. But if there is anything that is dependent upon the credibility of either the defendant's testimony or Detective Kopsel's testimony, the state would argue for the reasons of her being impaired by her own admission on the afternoon of February 24th, still from the night before, that her credibility is less than Detective Kopsel's, and of course she has a bias and interest in the outcome of the case, whereas Detective Kopsel has no motivation to not tell the truth about whether she used deception to bring the defendant down to the police station, because that's perfectly acceptable. So we're asking you for the reasons that we stated in our multiple responses to their multiple amended motions to deny their motion to suppress. Thank you.
Any further argument, Mr. Owens?
No, Judge.
All right. Tomorrow is a court holiday. The court has had the opportunity to review all the case law. Court's going to prepare a written order, and you'll have it before the close of business tomorrow. Courthouse may be closed, but I'll be here working.
For the record, there's 2 exhibits that I tried to introduce. They will be admitted
Correct.
to the record.
Yes, of course. They were pre-marked. Moving now to the defendant's motion for a right to hair, cosmetics, and civilian clothing without restraints for trial. State, what, if any, positions do you have with regard to the restraints?
Again, we've already decided that issue. I don't know that there's been any new allegations alleged in the motions by Mr. Owens on behalf of the defendant, but the court has decided that already, and unless there was some sort of change in position or authority, then the court should maintain the law of the case.
Response.
Just a clarification, but, she's here today and she's in handcuffs, so she has difficulty writing.
Let me just interject for 1 second. She will be hands-free.
Okay.
So the issue is the leg restraints.
And Judge, she's presumed innocent. I understand security has an obligation. There's 3 doors. I assume we're going to be trying the case in this
Yes, sir.
courtroom. There's 3 doors. I know that we've got several security officers here in case she were to try to flee. But she's got no access to weapons or anything of that nature. She has a fundamental right to a fair trial. She has the fundamental right to a presumption of innocence. And if the jury were to see any restraints on her freedom, they're going to automatically assume the worst, that she is a danger, and the people automatically will take that to heart, and it will affect their decision when they go back into the jury room. So, yeah, she's going to be at the table. I don't know if we switch it. Does the prosecutor go over here?
No, that's your table, sir.
That's my table, closest to the jury. So she'll be sitting here with the other 2 lawyers and I, and the only time they're going to see her walk in and out is she's always going to be in the courtroom.
They're never going to see her walking in and out.
So the only time is when she testifies. So I guess I don't know if you have leg restraints that she can wear and walk, but we believe it's not necessary. And of course, we definitely don't want them to see her walking funny or hear something funny or see something funny, and she's walking from the defense table to the witness stand to testify on her own behalf. But I don't think it's necessary to have leg restraints. I think once she gets in here in the trial, beginning Monday, jury selection, and I assume the tables are going to stay here?
The privacy panels will be located in front as well, which will prohibit our jury from being able to see any of the leg restraints that she has.
I don't think it's necessary to have the leg restraints, Judge. I think you can bring her in with the leg restraints, but take them off right before we get started. I don't see a problem with that. I don't think she's a threat. You know, there are times when criminal defendants are in a trial and they misbehave in the middle of the trial, so they have to be restrained. But Sarah Boone, as far as I've been involved, and I think prior to that time, has always been polite and cooperative, and she understands the importance
What about the shouting match you guys had?
of behaving, and I have every intent that she will comply with the court's directive and she will act appropriately throughout the trial. I do not believe any restraints are necessary during this trial.
Anything further as to that issue?
I don't believe that's case law authority on the issue. I believe.
All right, thank you very much. With regard to your request for clothing in that, you could certainly go to the jail and provide, have whoever it is that you want to meet with her in the meeting area to get measurements from her and provide clothing. The clothing for trial will have to be provided to her at the Orange County Jail. That will be brought over with her in the morning, and then she'll be able to be dressed out downstairs. So your motion will be granted with regard to the clothing. You'll have to address with the jail, having a person come in there to take her measurements. They may have to be with you, counselor, in order to facilitate that. But the clothing will have to be dropped off at the jail, and it will be transported with her in the morning each day of trial. Okay. With regard to the appearance issue, do you have any other further argument as to that?
Judge, just what's stated in the, I made some legal arguments in the defendant's motion for the right to hair, cosmetics, civilian clothing without restraints for trial. Just the arguments in there.
Yeah, what about the rest?
And the Estelle case that you cited to, spoke to being dressed out in a prison garb. Doesn't really address
Makeup,
prison guard and
hair.
shackles. It doesn't address any beautification or anything along those lines.
I just think it's, it's just part of a fair trial.
The other problem is it's contraband. That stuff's not even.
I don't know. Mr. Owen says I think a lot, and Judge is like, just give me the case law. Yeah, but I think. Oy, oy, oy.
Been purchasable at the commissary at the jail, any makeup or anything along those lines.
Well, I'm going to have the two paralegals here. I say the paralegals. One's a lawyer now, and the other is a consultant. But they're females, and they can bring the cosmetics in and apply it either here in the courtroom or just outside the courtroom. I'm sure there's a waiting room. There's no place where we can apply any.
You can't put them back there because we can't allow access back there. That's for corrections and for the sheriff's department and for the inmates.
Holy shit, what is this, a wedding? Do you guys remember, have you guys ever attended a wedding and then the bride asks you, oh, hey, I see that you're pretty decent with makeup. Can you put makeup on all the other bridesmaids?
Can she be allowed, can the two females on the team, can they be allowed to apply some type of makeup to Miss Boone?
State?
We don't have any dog in this fight. I've never heard of it happening. That doesn't mean it's not permissible, but
If you want to try to do it here in the courtroom, that's fine. But be advised that, when we start court, we start court.
You might be halfway done.
And I intend on starting at 9 o'clock every morning.
You might have one
So
more
I'll
guy
have
later.
pleas every morning and other matters because the court still has other business at 8:45, and I plan on bringing the jury up at 9 until we select one, and then starting at 9 every day thereafter. So your motion will be granted with regard to the clothing. You can perhaps someone attend, travel to the jail with you, sir, Mr. Owens, to take the measurements. You'll have to provide clothing at the jail. With regard to the appearance, it's denied to have anything happen at the jail or happen in any of the secured areas. But if you want to attempt to have members of your staff apply makeup prior to trial, you certainly can do so. Court will provide you a written order with regard to the request to removal of the leg restraints. But the hand restraints will be removed.
Yeah, that's risky, man. Because I think it's risky because if you're sitting there and your makeup looks bad, you're better off just going clean face, bare face. You don't want to be sitting there with like super red cheeks, or like if the eyeliner is like screwed up, if you're trying to draw the eyebrows in, if they look all jacked up or too dark. Like, I think it's just best to just leave it alone. Or the foundation is off and you look too cakey. Like, I don't know about that.
Moved.
Judge, and then I think there's something about hair as well.
I think that it falls under the same
Okay.
analysis.
It needs to be done in the courtroom.
Yes, sir. And then the last item teed up for today is the, I'm sorry, yes. Yes. Office have just advised.
Okay, so what is he saying?
So corrections in the Orange County Sheriff's Office have just advised me that the concern is if makeup is affixed and then she's taken back downstairs and then taken back
Oh, how do you take off the makeup, I guess? You need to get makeup remover?
to the Orange County Jail. They don't know if it's contraband. They don't know what's placed on her person. That's the concern.
There's just going to be some facial makeup.
I understand, but
I don't see.
DOC and Sheriff's Office are telling me they can't do it because of the concerns that were just outlined after she's returned to the Orange County Jail facility.
Okay.
And the worst is if it's like waterproof makeup and she can't get it off, and then like she's gonna, I don't know, and it's still gonna be like maybe on clumps of it next day possibly if it's like mascara. I think she looks fine. She doesn't need makeup. She looks fine.
Okay.
All right. You'll get an order with regard to the restraints no later than tomorrow. Moving now to the state's request for protective order. I've reviewed that. I need to understand what you're looking at, Mr. Owens, with regard to these custodians and super.
They basically just said that like when she comes back to the jail with the makeup on, that could be considered contraband, like the makeup on her face. Like they don't know what the ingredient is made out of and all that stuff. I don't know if you can make a bomb out of it. I don't know. They just want to be on the safe side, you know?
Supervisors at the state attorney's office.
I did not realize that was going to be addressed today.
Yes, my JA had emailed all y'all, I think last week after it was filed, that said this would be added to the hearing for. I guess that was filed on Monday, forgive me. I had emailed y'all and said that it would be addressed today.
Is he prepared?
That was relating to me subpoenaing the enlisting the I think it was
It's the third amended witness list lists certain people as witnesses: custodian of records, Orange County Office of State Attorney, domestic violence supervisor for the Office of the State Attorney, victim advocate supervisor for the
Oh, this is the protective order.
Office of the State Attorney, and misdemeanor supervisor for the Office of the State Attorney. And the state is seeking a protective order on the grounds that it's work product or opinion product, and requiring prosecutors to disclose work product and impede criminal prosecutions is violative of Florida law.
Judge, as you know, we have filed our notice of intent for battered spouse syndrome
Yes.
in conjunction with self-defense. And we have listed and plan to introduce the fact that George Torres had been arrested, I think, 3 or 4 times prior to this event. And I think on 3 of those cases, the case was dismissed against Mr. Torres. And it's going to come out that Sarah Boone had requested the charges be dismissed. And I believe it's going to come out probably through expert testimony that that's one of the conditions, or that's one of the things that they try to do, bond you out of bail and then get the charges dismissed as a battered spouse. That's a common theme. So ultimately, the jury is going to hear about that, but the jury needs to know it's the ultimate position. The victim doesn't have the final say. It's the ultimate position from the state attorney's office as to whether to prosecute a case or to drop a case. Yes, they are to consider what the victim wants, and they are to consider their request, but ultimately, the state attorney has to make that decision about whether a case is dismissed.
What are you going to be asking from these persons?
That.
How would that not be protected by work product?
Well,
to whether or not it was a
if it comes out that she went down there and requested the charges be dropped and they were dropped,
then that gives the impression that she had the power and authority just to come down to the state attorney and ask the charge to be dropped, and they would. When in fact, the ultimate call is the state attorney's office. They don't have to drop cases, even if a victim claims they do. So just that decision by the state attorney to drop it was their decision. They considered the victims, but it was their decision to drop it and their power and authority to do so, not the victim's authority.
Okay. Response?
Judge, that's
Is she asking for the state to pay for hair and makeup, or is she asking permission to hire people herself for hair and makeup? In the motion, they didn't really specify who was going to pay for it, but they just asked for to have a professional to do hair and makeup. That's what they asked for. And I'm assuming since she's, an indigent person or an indigent defendant, the state would probably have to pay for it, but we didn't get that far.
Opinion work product, that is absolutely protected. I don't understand why he believes that arrests and dismissals are relevant. What is relevant in a self-defense case is if the defendant is aware of specific instances of violence that the victim has committed, or reputation evidence that can come in from any is aware of specific instances of violence that the victim has committed, or reputation evidence that can come in from anybody, and it does not matter whether the defendant's aware of it. The notion that this sort of evidence would be admissible, much less through the vessel of sworn prosecutors, and they have now gone ahead and named people who aren't even involved with the cases. Matthew Storch, Christina Mills, and Aaron McCullough, our head victim advocate, have all now, I learned while we were at the jail this afternoon, been served with subpoenas by the defense, and we are moving to quash those. Prosecutors and victim advocates and other support staff cannot be forced to come in and say why they dropped a case. That is opinion work product. And if they want to get public records about these cases and try to get them moved into evidence, then they have to do public records requests or compel discovery from the state attorney's office, which I believe we all have. The state has just been dropped with her medical records that Investigator Lane got in 2021, even though they keep on saying in their amended discovery exhibits that they don't even have this evidence. We got dropped last Friday, the Aspire records and the Advent Health records that have documentation that Billy Lane picked them up in 2021. So the defendants had these things that are getting dropped on the state.
2021? The Aspire records and Advent Health records.
And that Billy Lane picked them up in 2021. So the defendants had these things that are getting dropped on the state for years, and we're just getting dropped on us this Friday. And now we are having to combat subpoenas and requests for documents. It is opinion work product. The people that they have listed didn't handle those cases or make those decisions, but that is the ultimate protection, is why we drop these cases. And it's up to the defendant if she wants to come in and say, yeah, I asked to get these cases dropped. I mean, that evidence is coming in anyways through her phone extraction. She is immediately working to bail the victim out. She's immediately working on dropping charges. In fact, there's a video of her coaching the victim on how to drop charges against her on her phone. So all that evidence is
Say what now?
going to come in, but it cannot be coming in through opinion work product of the assistant state attorneys and our support staff.
Any further argument?
I didn't make the argument. I did not make the argument that the state attorney was going to be called to ask why they dropped it,
Okay.
as he just referred to, where they had to explain why the case was dismissed. No, the reason for that is just to explain that they have the ultimate power to dismiss, not the victim in a case. Not why we chose to drop 3 cases against George Torres, but they have the ultimate authority. The victim does not control the case. The state attorney does.
I could have sworn he said. Okay.
You have a written order on the motion, protective order for tomorrow, as by tomorrow as well. Anything else, State, we need to address?
It appears, and again, been conducting motions all afternoon, it appears that we are set to allow the defense to depose our battered spouse syndrome expert at 10 a.m. tomorrow? Yeah. And that will be done virtually?
With regard to the deposition of Dr. Brannon, the deadline is tomorrow.
That's set at 3 p.m.
Okay, that's still set at 3 p.m.
Yes. There will likely be a pending motion to strike if his testimony is duplicative with Dr. Harper's. My understanding from the defense is he's just going to explain what battered spouse syndrome is. It's unclear why or how that would be different than Dr. Harper explaining
Exactly.
that.
Is that taking place here, or is that taking place in South Florida? Virtually?
Unfortunately, due to time constraints, I cannot be everywhere at all times.
Okay. All right.
Judge, and then on Dr. Brannon's deposition, yes, it's set for 3. I'm just learning now that the expert is going to be available at 10, y'all's expert, by Zoom. And we did
I don't know. He just did a huge sigh there. I wonder if he's like, you knew this. I don't know. There was maybe I'm just overreading the situation.
expert is going to be available at 10, y'all's expert, by Zoom.
Oh, maybe he's just confirming.
We
Okay.
did talk about that at the jail, trying to schedule something for tomorrow. So she just evaluated Sarah Boone from noon to 2, and then I'm going to take her deposition at 10 tomorrow morning by Zoom. And then we're taking Dr. Brannon's deposition. If they file some type of motion about that, then of course I'm going to respond. We're going to need to have a hearing on that.
Okay. Go ahead, I'm sorry.
Those 2 things are the only 2 things that I believe we have left prior to jury selection on Monday.
Okay. If any motions are filed by anyone moving forward, please favor a copy to my judicial assistant upon filing. And if there's any authority that you intend on arguing that's not cited in the motion, please provide me that authority as well. Although it is a court holiday, the court will be working tomorrow. I will endeavor to get you written orders on all of these things no later than the close of business, hopefully earlier than that by tomorrow. On Monday morning, State, if you could please bring a copy of the score sheet so that when I colloquy Ms. Boone prior to trial about the charge, the potential penalties, everybody's on the same page as to what those are. Okay?
Yes.
And if y'all could send me that, I'll go out to the jail. I'm going to be here.
If you could favor him a copy of that tomorrow or Friday so that he has the opportunity to review that score sheet with Ms. Boone in advance.
Yes, and we're going to be filing a motion in limine to exclude the battered spouse syndrome testimony that will need to be addressed. Just waiting to see now how the depositions pan out tomorrow, but based on what we witnessed this afternoon, it's the state's position that we're going to need to file a motion to eliminate.
Okay. All right. Appreciate it. All right. Thank you all very much. We'll address scheduling of any motions on Monday, and it may be a circumstance where, as the court had identified earlier, that we're just going to be looking at cause issues and what people may know about this case. That'll be happening before we turn it over to you all, which would include, Mr. Owens, your opportunity to voir dire on any defenses that may be being raised in this case. So it may be we may get a panel and then ask them to come back later in the week so that we can have those motions after we get that panel of 50, once we deal with all the cost challenges. Okay? All right. Thank you all very much. We'll see you Monday morning at 9 a.m. Court's in recess. Thank you.
What a long hearing. I was hoping to do the interrogation today, but I'm starving. I'm so hungry. I can't sit here and do the interrogation. But I think we'll do it tomorrow, because tomorrow, I don't think there's anything going on tomorrow. We'll just sit here, do the interrogation, and then as the judge's orders come through, we'll read them together. Oh boy, a lot happened today. I'll do a quick little recap in case you guys missed anything. Now, the audio for today was really, really bad. Usually when I edit the video, the audio is a bit better. It's a little bit more balanced, and it doesn't peak as much. So when I edit this video later today, hopefully the audio will be, the audio will be better, but I will have a lot to work with. The audio was super crusty today, man. Is that it? Is that it of the live feed? Oh, there's more. I don't know why the stream froze, but there's no more. That's it. We get the rainbow and the gray squares. Okay. Oh boy. Okay. Whew. We got a lot. I didn't expect Sarah Boone to testify today. Honestly, when Mr. Owens said that Sarah Boone was going to testify, I just thought he meant during trial that she was going to testify to it. I didn't know that he was going to actually have her go up there today and give her side of the story. But I mean, it makes sense, I guess, for the judge to make his decision. So today we address 3 motions, and I really thought today was going to be a short court hearing today. I thought maybe like 40 minutes tops. Okay. All right. So what do we go over today? I don't have my glasses on, so this might be a little bit of a struggle. It's a little bit fuzzy. We did 3 motions today. One was a motion to suppress. One was a motion or for the rights for the hair, makeup, cosmetics, to remove restraints during trial. And then the last motion was in regards to I forgot already. What was it? We just talked about it. Oh, it was protective order. Okay. Let's go through each one. So today, a lot of things were filed, and we were trying to catch up with it as the court was starting. They did start late today. For the motion to suppress, the defense wants to suppress a 2-hour interrogation video. Now, this was already argued back and forth a couple weeks ago, and it seems like today the defense didn't really add any more value to their arguments. There was a lot of back and forth between him and the judge, and it was exactly the same thing that happened already in a different hearing. So the defense wants to suppress a 2-hour interrogation video. They said that the detective at the time did not read the Miranda cards fully, and so there was like 9 questions on the Miranda card, okay? She didn't read the 9th question. Well, the judge and the state is like, okay, well, if you're looking at case law, for Miranda, you got to ask the 4 main questions, which is like you have the right to remain silent, blah, blah, blah. You have to ask those 4 statements. Sorry, you have to say those 4 statements. And so that was done. Whether or not this was, part of policy that she had to read the 9th question on the card, that was the issue the defense was bringing up. But the judge is like, no, if you look at the case law, you don't need to say the 4 things about the Miranda. And so lots of back and forth with this one. We actually had the Detective Chelsea Kepsel. She went up there and she testified, talked about how she was on the scene. She was a detective. She asked Sarah Boone to come in, do the questioning, blah, blah, blah. And her explanation as to why she didn't ask the 9th question, why she didn't ask the last question that was on the card, it was because the card that she had at the time only had 8 things on there that she was required to read to Sarah Boone. And so James Owens was like, oh, did you just not make an effort to get the most up-to-date card? And she's like, well, I got the card in 2013 when I was hired, blah, blah, blah. And so that's about it. That's why she didn't read the number 9, because she didn't have the number 9 on the card that she had in possession at that time. So she went up there, she testified. And then we had Sarah Boone also went up there and she also testified as well. Where's Sarah Boone part? Sarah Boone. Oh God, there's a lot today. All right. Sarah Boone. Oh, there was a lot of spicy back and forth between well, it wasn't super back and forth, but Mr. J, definitely threw some jabs today at Mr. Owens. I think he's starting to really lose his patience with Mr. Owens, and I'm starting to hear it a little bit in some of the things that he's saying, and he's kind of like sighing out a little bit. Let's see. Lots of sustained. I remember. Oh, so Sarah Boone went up there and where the hell is the Sarah Boone part? Oh, here's the Sarah Boone part. Okay, Sarah Boone part. Sarah Boone went up there and testified, and she was talking about the mental state that she was in. She was like, I was very confused. It was very hazy. I didn't understand, the amount of people that were there, what they were doing. I was really worried about my dogs. I was worried about my son. I was in shock. I was traumatized by the situation. And then I'm like thinking about the body cam footage. I'm like, I remember her being really erratic, and she was asking for, she was really thirsty. She wanted to drink something because, when you're hungover, you're probably really thirsty. You're super dehydrated. She wanted her Dr. Pepper. She wanted her cigarettes. I don't remember her saying anything about like, oh, how are my dogs? Are my dogs okay? Can I go get my dogs? Can someone come here and get my dogs? I don't remember her asking about her son or anything like that. But, maybe it was all in her head and she didn't say it out loud. But when she went up there and testified, she definitely had a different demeanor in terms of you're trying to compare her to, the language that she uses and the letters that she writes to the judge, right? She's like, it's just very different, very confrontational, very accusatory. And even when she's going back and forth with the judge in these hearings, we got a different side of Sarah Boone. This Sarah Boone was like, oh, hi, my name is Jody Arias, and I'm here to testify, and I'm going to talk very quietly, and I was just so confused. I didn't know what was going on. Like, oh my God, I'm a victim. That was the feeling. That was kind of like the feeling that I got when she was up there. So we're getting a little bit of a preview about Sarah Boone if she were to go up there to testify for the trial. So the thing that really stood out to me with Sarah Boone, because she was trying to say that like, oh, she was tricked by detectives into asking answering questions. She was tricked by the detectives and giving them the cell phone. I think she was trying to say that like, hey, the detective came up to me, was like, where's your phone? I told her where my phone was. It was on the kitchen counter. She grabbed the phone. She came up to me and was like, hey, put your PIN number in. And she did it. And then she said she went away. No waiver was signed before then. However, when Mr. J came up there to cross-examine her, he was like, okay, so you admit that you were impaired from alcohol, probably from the day before, right? Because you were drinking the day before. She's like, yes. And he's like, you didn't go to brunch or anything like that? And she's like, no, I didn't go to brunch or anything. He's like, okay, well, is it possible that maybe your memory could have been affected by your alcohol? Because it seems like your version of events is different than Detective Kepsel's version of events. And at that point, you could tell that she was stuck. And, Mr. James Owens tried to bail her out at that point, and it's obvious that she realized she was kind of in a trap. So definitely worth watching that part. There were some objections in the court. I remember the judge telling Mr. Owens that, okay, if you're going to make an objection, I don't want speaking objections. I want you to give me a legal objection. And then Mr. Owens like, I don't have one. He's like, okay, next. So lots of objections, lots of going back and forth. We had some good back and forth between James Owens and the judge today. The state conceded that it was a custodial interrogation. They're not saying that it wasn't. Oh, gosh, I have a lot. So in regards to the motion to suppress, the judge said that even though tomorrow is a court holiday, he's going to be working. He'll have his ruling tomorrow, a written ruling, so we can read that tomorrow when we watch the interrogation. And then... okay, next was hair, makeup, restraints. Oh, Taxi. Thank you so much for the Sunny 249. Thank you so much for your support. I appreciate it. Thank you, thank you. Is she going to sack Mr. She can't be sacking Mr. Owens. Nah, she got to keep him. It's the best that she's got right now. Hair and makeup restraints. Okay, so the restraints thing. The state had no issue with Sarah Boone being hands-free. They already agreed to her being hands-free. However, she's going to have leg restraints, right? I think they're going to give her probably like leg shackles. And so... they were fine with that. Mr. Owens thought it was unnecessary to have the leg restraints, and he kept saying, I feel. No case law, really. In terms of hair and makeup, I think they were trying to figure out how to put makeup on Sarah Boone. They were like, oh, we can just do the makeup here. We can just do the makeup in the back. And the judge is like, no, you can't do that. So they wanted to have the makeup done in the courtroom. But, the judge was like, okay, well, you're going to have a really small window where you can apply the makeup, because I think Mr. Owens pitched having, he called the paralegals. They're not paralegals, but he pitched having the paralegal, because they're females, to do the makeup for Sarah Boone. And the judge was like, you're going to have a very short window of time. Like whenever the court starts, at 9 a.m., we're just going to start. Okay. But later on, the jailhouse and the sheriff's office was like, oh, no, we don't want her having makeup on, because that could be like contraband, like her having makeup on her face and they have to bring her back in. It could be contraband. We don't know what the ingredients are made of, blah, blah, blah. So seems like a no to that one. And for the last one, the protective order. Okay, so the state said that there were, they got a witness list of all the people that the defense was planning on subpoenaing for the trial to have to testify. And so some of the people on there were listed. They worked for where is it? Some of them were prosecutors. Some of them worked for like the victim advocate's office. And Mr. J was arguing that we can't be, we don't need to basically expose their work product. That's something that's protected, and you just can't ask for it. However, if the defense really wants to, maybe they can put in a public records request. Yes, put in a public records request, and he can do it through that. Mr. Owens was like, oh, we're not trying to ask, because the reason why they want this in is because they're trying to show that George was arrested 3 to 4 times, and that 3 of those times it was dismissed. However, he's trying to argue and say that it was dismissed by, the state attorneys. It wasn't dismissed by Sarah Boone. She didn't say that she wanted to have it dismissed. I guess. I think that's what he was trying to say. And he's not asking for why they dismissed the case. He just wants to tell the jury that it was dismissed because it was chosen by not Sarah Boone, I guess is what he's trying to say. And so the judge was like, okay, well, I'll have a written order for that tomorrow as well. So today, Sarah Boone met with the state's battered spouse expert. They met with her today, I think for about 2 hours. I think I heard, was it either 10 to 2 or 12 to 2? They're going to have the deposition done tomorrow, but the state says, hey, like based on what we heard so far with Sarah Boone meeting with our expert, we're still going to file a motion in limine about, to exclude the battered spouse defense. So can you imagine if Mr. Owens, if Sarah Boone, if they're not allowed to introduce the battered spouse defense, what are they going to do? What are they going to scramble for next week? Because, Dr. Julie Harper, when she's testifying, sometimes next week or 2 weeks from now, she's going to rely on the battered spouse defense, but they don't have that to rely on. What are they going to work with? I don't know. It's going to be a hot mess. Was there anything else? Monday, they're going to address the motion. So we'll be here on Monday. And then Monday is also when jury selection is going to happen. And that's what I got. That's what I got today. If I missed anything, just feel free to just write it, because I was just trying to quickly skim through all of my giant notes that I have today. Any news on the Adelson case? I have not heard anything about the Adelson case. The only thing that I heard was possibly, I don't know, it was in the grapevine. I don't think it's confirmed or anything, but maybe a plea deal. I don't know. We'll see what happens with that one. But so far, I haven't heard anything about the Adelson case. I think I heard that if the Adelson case for Donna Adelson, if that case is going to be tried, most likely it'll be in 2025. That's all I remember reading about it. It wouldn't be this year, because I was like, oh, maybe, they'll schedule it for November or December. But I heard if it does happen, it'll probably be like early of 2025. But yeah, I wonder how Donna feels about her son, Charlie, now. She can make a bomb out of a lipstick. She's a straight A student in high school after all. So yeah, no pho for Donna. So tomorrow, we'll watch the interrogation video just as a refresher. Why not? And then as we're watching the interrogation video, we'll just keep refreshing the Orange County Clerk of Court website to see if, what the judge has decided on the two other motions. So the motion to suppress, and then also the protective order. All right. All right, y'all. I was trying to go through that really quickly because I'm hungry. I need to go eat. I need to eat lunch. But I hope you guys have thanks for joining us for today. We're definitely going to be streaming the trial. I am going to stream the trial live. I think we'll start when the court starts. I was a little hesitant because usually I like to speed it up a little bit, especially at the pace and the speed that some people speak at. I feel like it's better to listen to them at 1.25 or 1.5 speed. But I think it'll work out fine, because I think we'll start the trial when the trial starts, which is going to be 6 a.m. my time, 9 a.m. If you're in the Eastern time zone. And I mean, usually we'll pause and talk, and then we can speed up a little bit here and there and stuff like that. So no, I haven't watched it. I haven't watched it yet. No, I haven't, because I was planning on doing all this with you guys. And then, sometimes the hearings go on for really long, and then I get really hungry, and I'm like, okay, well, I'm going to end my stream right now because I'm starving. Hey, Fat Yoshi. Yeah, Books with Sarah. Thank you. No, thank you. Yeah, that's the Discord right there. Guys, if you guys haven't, feel free to join the Discord. Have your notifications on. You can have it on. I usually do the notification on Discord when I'm about to go live. And then on YouTube, have your notifications on as well. And then also for my channel, I think what I'm going to do is I'm just going to separate out so for this channel, I'm just going to do all the true crime stuff, because a long time ago, this channel was a bunch of other stuff. And then I started doing the true crime stuff, and then I would do a mix of true crime stuff and all the other stuff. But I think now, I'm just going to just keep it all true crime stuff and just have it separated, because I think I'll like that better. So for the vlogs and all that stuff, I'm just going to keep it on like a different channel for myself. And then if you guys want to check it out, feel free. But I think for this channel, we're just going to do all true crime stuff. Sometimes it feels weird to mix the true crime stuff with like my vlogs. And I'm like, I feel like it doesn't belong here anymore. Before we used to have a good mix of like everything else, but I think it's better just to do all the true crime stuff on here. And then I'll just have a separate channel for like all the other stuff that I feel like uploading. Oh, thanks. I appreciate it, Nicole. Thank you. Her birthday is coming up. Oh, yeah. You guys can go and wish her a happy birthday. Yeah, feel free to join the Discord. Oh, God. We do puzzles. We do paintings. We play hide and go seek also. Oh, yeah, Rain. But yeah, feel free. My niece is 9 out of 9. Oh, her birthday's on 9/9. That way you'll never forget. Do I have two channels? Okay, so I made a second channel a long time ago, and I'm just gonna use that channel to upload all the vlogs on. So I finished uploading the vlog. I just haven't made the thumbnail yet. But when I do, I'll just post in the Discord. So you guys want to follow that channel for free as well. But yeah, that's about it. I'm going to go eat. I am hungry. Tomorrow's a court holiday. I believe tomorrow is a Jewish holiday. Rosh Hashanah? I don't know how to pronounce it. Actually, tomorrow I think is the Jewish holiday that made Donna Adelson decide to push her trial to happen a lot sooner, because I think she was expecting to go back home by the Jewish holiday. You know, she probably expected to be acquitted. I think that was the holiday that she was hoping to be home by with her husband, Harvey. Yeah, Rosh Hashanah. I don't know how to pronounce it. They never taught me how to pronounce it when I was in school. But yeah, tomorrow's a holiday, and then the judge says he's going to be working. So I will see you guys, I think tomorrow. If I don't have anything done, I think we'll do, yeah, I'll see you guys tomorrow, I think. Because I want to watch the interrogation, and then we'll cover the motions, the decisions that the judge made in regards to the two motions. The decision or decisions? Decisions. Anyways, I hope you guys have a good one. Rosh Hashanah? Rosh Hashanah? Rosh Hashanah. Oh, is that how you pronounce it? Rosh Hashanah? Okay, good to know. Thank you. All right, y'all. Have a good one. Take care. I hope you guys have a good one. Again, thanks for hanging out. And I will have this stream edited out into a smaller video, usually recapping everything in case that's better for you guys. Or, you know, if you guys ever want to, we always have the stream videos are all if you want to listen to the entirety of it. Because sometimes you miss, you know, sometimes watching things like during a live stream is very different than when a video gets edited, because you kind of miss all the silliness in between that happens in a courtroom. Oh yeah, Mala, I saw that you're from India. You're in India right now. That's so cool. That's awesome. 3 a.m. here in India. Oh wow. Yes, have a good night's rest. Take care. And yeah, you guys stay safe out there. I will see you guys hopefully tomorrow. Feel free to join the Discord, like I said again, and notifications will be up. Shit, I didn't even spell it right. All right, y'all. Bye. Oh.